Items for pronouncement of judgment. Item number 22, RSA 240 of 2012.
Appeal dismissed.
Item number 23, RSA 115 of 2014.
Appeal dismissed.
Item number 24, RSA 99 of 2015.
Dismissed.
Item number 25, WPC 9023 of 2019.
Petition allowed.
Item number 26, WPC 4850 of 2022.
Petition allowed.
Item number 27, WPC 5327 of 2023.
Petition allowed.
Yes, Mesh.
Kind request, my lord. On CRP motion, my lord, if possible tomorrow, Friday my difficulties, my lord. That's all.
Okay.
Grateful, man.
May I please, your lordship? Let me mention listing of an stay matters, your lordship. Stay 4/11/24 is the last date of posting. Maybe
When do
post
you-
it next week, any date, your lordship, please.
On
Take it that.
25th.
Yes.
May I please, lordship? My lord, my father's paid servant identifying as the second wife has got probate certificate. In respect of 6 bighas of land. It's a very urgent matter. It may kindly be taken tomorrow, my lord. Do you have already filed yesterday?
No, not tomorrow.
On 18th, Friday.
Friday? Okay.
May it please, my lord. Prayer for listing of an unlisted matter for today, my lord. My lord, it is a CRPIO, my lord. My lord, it is under the unauthorized occupation of public premises act, my lord. Either today or tomorrow, my lord, eviction drive will be carried.
Tomorrow.
My lord,
Tomorrow.
deeply.
May I please, Lord? Listing of RFA, your lordship.
When?
Friday,
Motion matter?
motion. RFA,
May it please your lordship, with the consent of the other side, I beg to mention items 17 and 18 of today's list. Subject to the convenience of this honorable court, if this matter may please be taken up after 2 weeks.
You are for the petitioner?
I am for the appellant, my lord.
I'm for
Okay.
the respondent, your lord. The last time also she.
I am recovering from a surgical intervention, my lord. I need some time, some accommodation.
Okay. As agreed by learned advocates of both the parties, recess shall list the matter. When suggested at
31st or 29th? 29th or
29th,
Can it be
29.
31st, my lord?
29th.
29th, 31st, we have many cases.
Yes.
31st, my lord, then in case, my lord, 5th of August,
okay, all right.
deeply obliged.
People.
My lordship, I beg to mention 2 MFAs, my lord. These are under Employees Compensation Act, then it was challenged. It's a 2020 matter, my lord. And I am praying to be listed under the heading of hearing, my lord. The matter was, my lord, I have given applications, my lord, 2 times. Tried that matter to be listed, but unfortunately it did not.
When do you want?
My lord, next week, Thursday, my lord, if it is
Let
convenient.
us do one thing in the first week of August.
My lord, please, my lord will indicate a date. my lord.
Okay.
7th August.
May it please your lordship. My lord, I have filed a CRPIO, my lord, yesterday, my lord. My lord, this is against the application filed by the petitioner for calling of the register to prove the, my lord, the fraudulent of, my lord, marriage certificate, my lord, which was rejected by the family court, my lord. And the next date was fixed on 16, my lord, for judgment. So I pray it for today or, my lord, if
Not
possible,
today.
tomorrow, my lord, 6.
Let please, your lordship. I beg to mention 2 RSS, lordship. We have filed IS for implement of the parties, lordship.
When do you want?
This Thursday,
No.
Next week,
Next week.
on 23rd.
23rd. Obliged.
May it please your lordship, I beg to mention for listing of a civil revision petition which I have filed it yesterday. I'm praying for listing of it by tomorrow. As there is some urgency, in this revision petition, we are praying for a direction to the learned trial court for disposing of the injunction petition on the next date. Since the month of February 2025, it has been pending. And the plaintiff, and there is an status quo order.
You go and file an application there.
Lordship, we have approached the learned trial court, but thereafter also it.
When?
On.
And how you have approached the trial court?
We have filed the petition.
You have the copy with you.
Right now, I don't have, but I have
It is
annexed
a
it.
part of the record.
It is part of the record.
Okay.
Thursday.
Thursday. Okay, Thursday.
Published.
May I please hold? Sorry.
May it please your lordship. My lord, a particular matter regarding MAC appeal was fixed for hearing, but otherwise we are praying for
When?
list- sometime in due course, my lord. But what we are praying is that the matter be listed for order subject to my lord's kind consideration. We'll be only praying for a remand, not for adjudication. If that be considered on that count, we are praying for listing it for others, otherwise not. If your lordship considers. It so happened that the direction was that the whatever compensation amount is there, it should be given by X, the insurance, and not the Y. We say it should be given by the Y also, in some cases and some not. So if that is considered by the court, the tribunal below, as to whether out of who would to pay, that much it can be, the excess can be done below, and then we can come back. If
When do you want?
subject to my lord's convenience,
24th July,
24 July, could it be just a day prior?
23rd July.
23rd July. I'm obliged, lordship, grateful.
May I
Yes.
please hold? We are for listing lordship high for releasing of 50% lordship.
Oh,
Releasing of 50% lordship in MSC case.
okay. When do you want?
Friday lordship.
Friday.
I'd like to mention CRPIO for withdrawal.
When?
Any date nearest date.
Thursday, 17th.
No, may I please, this second appeal against order for withdrawal matter on Friday. Hello, bless.
May I please your lordship? Lordship, I pray for listing RFA matter on tomorrow or day after tomorrow, lordship.
Motion?
Motion, lordship.
Monday, lordship, on 21st.
Lordship, some urgency is there because the matter has been filed long back before the vacation. Till today, it has not been listed, lordship. So,
Anyway, we'll take it up on Monday.
Monday, on 21st. Already so many
Okay.
cases in this week.
May I please your lordship? Lordship, my prayer is for listing of RFA matter. See, any day
For?
for listing of RFA. Regular.
In which column?
In which?
Motion or hearing?
Admission.
Admission?
Yes.
30th July. 30. Okay.
I beg to mention for listing one testamentary appeal. Lost is not listed since last listed on 04/06/2020
hearing or-
orders. For orders,
28th July.
28.
Yes.
May be please, your lordship. Lordship, I beg to mention for listing one MFA in hearing column. Lordship, matter may be listed on 22nd July.
Hearing, lordship, but in the month of August, not possible. 7th August.
Okay, obliged.
No, please, your lordship. Lordship, with concern of the other side, I beg to mention item number 13 in daily list, lordship. Lordship, matter will be adjourned for lordship for 4 days.
Mister, your good name?
Yan Borua, lordship.
N?
Borua.
N. Borua, learned counsel appearing on behalf of
And from MD Chaudhary.
MD Chaudhary, learned counsel for the petitioner with consent from the other side, press for listing the matter. When?
Respondent in this case, kindly one date may be fixed.
Okay.
Then I was left.
For hearing,
Hearing.
12th August.
12 August.
No, 12 Bishop point.
Okay.
Sure.
Oh, Kishore. On 19th August.
Hello, bless.
May it please, lordship. Lordship, I beg to mention one CRP IO for listing,
When?
if possible by 18th of July.
Friday, so many cases, lordship.
Monday?
Monday, 21st.
Lordship, execution proceedings is going on.
When the next date is fixed?
I'm completely not aware about that.
Monday.
21st.
Yes.
May it please your lordship, with the consent of the appellant, I beg to mention item number 5. My senior, Mr. Shantanu Chakraborty, is in bereavement, so the matter be kindly adjourned for today.
Your for respondent number?
1.
Lordship,
What?
I am appealing for the appellant.
Gotcha.
Okay.
Okay, as agreed by learned advocates of both the parties, this is a list the matter on. Copy.
For orders
Orders.
on 3830.
May it please lordship, I beg to mention listing of an IA in MSc Appeal 70/2023 will be listed on
For,
for hearing.
for,
MSc Appeal 79/2023
no, I is for what purpose?
for rewarding of award amount registered 50% amount.
For releasing the amount. Amount has been deposited in the registry of this court.
Yes, sir. Yes, sir.
When do you want?
Friday, this
Right.
Friday. Thank you very much.
Item for withdrawal 29 and 30.
Or I may be allowed to withdraw it with the liberty to file civil
Yes.
division petition.
Revision petition.
My lord, we have filed objection as well as affidavit in opposition yesterday. The cost may be imposed, my lord.
Those?
Cost may be imposed because inappropriate application was filed and we have already filed the affidavit in
And we
opposition.
file it today, my lord.
Though, my lord, we have been harassed, my lord, so cost may be imposed and liberty may be granted. We have no objection to that. Cost may be imposed.
You will file a revision petition.
Division.
So you can withdraw those petitions and file in the
And
petition
go
to
to-
file by.
Will be filed, my lord. No, we are praying for post.
No, is there any instance of imposing cost at the time of withdrawal?
My lord, since they have filed an inappropriate application, now they are seeking withdrawal. That is, we are not objecting to that. No, we are praying, my lord,
They,
may allow.
they have not been doing it intentionally, maybe inadvertently.
We are just praying, my lord.
Heard Mr. Roy, learned senior counsel assisted by Mr.
Hazurika.
I Hazurika, learned counsel for the applicant and also heard Miss
P. Mishra.
P. Mishra, learned counsel for the respondent. Mr. Roy, learned counsel for the petitioner submits that he has the instruction to withdraw this application. And also he submits that he may be granted, the applicant may be granted liberty to approach this court again by filing appropriate petition. Is Mr. Learned counsel for the respondent, however, submits that the respondents are being harassed by filing inappropriate application and therefore she raised that some cost may be imposed. However, taking note of the submission of learned counsel for both the parties, this court deem it appropriate to grant. Deem it appropriate to allow Mr. Roy to withdraw this application with the liberty to approach this court again by filing appropriate petition.
Order.
My lord, one thing, my lord, the certified copy is attached, we file it. So we will
Certificate copy enclosed with the application and the appeal, we return to the petitioner and the applicant, appellant.
Obliged.
Item for admission, item 1.
Yes.
My lord, I filed one title suit against the respondents. And for not to evict me without following due process of law. And in that title suit, the respondent filed counterclaim and I filed my reply. In the due course of the trial, I submitted applications for calling up the NJK's records, which in respect of the rent I am depositing in the court.
And due to non-taking of the steps, my right was curtailed. And thereafter, I filed one application under that is application is at page 95 and exact 5.
Number?
Page number 95 and exit 5.
Yes.
An application under 7, Order 7, Rule 14, read with section 151 CPC, seeking leave to allow the plaintiff to exhibit document concerning certified copies of the Miss NJ case records, concerning the said original Miss NJ case records, which are earlier called for on the basis of petition number such and such, and receipt of the said certified copy of the Miss J case records in evidence. I have mentioned those Miss J case number in paragraph number 2 of my that application. Altogether 16 Miss NJ cases, for which I have filed application for seeking leave to grant me to adduce the evidence by submitting the certified copies. And the learned trial court below, after hearing both sides, has rejected that application. That's why I have filed this application.
What is the ground?
Ground was that the earlier Miss J cases which were called for were rejected, calling of those documents. That's why my applications was rejected.
Show me the order.
Order H, it at page 105. The plaintiff and defendants as represented had the learned counsel for the plaintiff and the defendants on petition number such and such. The plaintiff had petition number such and such had stated that the plaintiff on earlier dated date itna filed petition number itna calling for the NJ case records, which was allowed, and thereafter the court closed the calling of the Miss NJ case records. On account of a closure of the NJ case records, the plaintiff had applied for certified copies of the NJ case records mentioned in the para number 2 of the present petition until that received the certified copy of Miss NJ case records number such and such. And the certified copy of other case records mentioned in para 2 are yet to be received by the plaintiff, which are likely to be received within a short time. The plaintiff was unable to find the certified copies of the Miss NJ case records as the original of those case records were called earlier. The plaintiff will suffer if he is not allowed to adduce the certified copy of the Miss NJ case records mentioned in petition number 6 in his evidence. Accordingly, the plaintiff has prayed for allowing him to exhibit the documents concerning the certified copy of Miss NJ case records, which were allowed to call on the basis of petition number such and such. The defendants filed a written objections whereby the defendants have stated that the petitioner plaintiff clearly depicts that the petitioner is seeking leave to rely upon the certified copies of some NJ case records which are not yet to fully obtained. Some of the certified copies in Ms. NJ case records are yet are not in possession of the plaintiff and are only likely to be received. The plaintiff petitioner stopped from relying upon the documents by certified copies at the stage of relying on the certified copies were not available at the proper stage of steps. No case is made out to grant the leave of the plaintiff petitioner to allow him to execute certified copy of Miss NJ case records. Accordingly, the defendants have prayed to reject the plaintiff petition number 6. Upon going through the contents of the petition as well as earlier orders of the court, it appears that the void order dated 7/2/2024, the plaintiff was allowed to call for the NJ case records, but on 4/4/24, the plaintiff was directed to take steps even after granting the opportunity to call for the NJ case records At the stage of evidence of the PWs, the plaintiff did not avail the opportunity to exhibit the NJ case record in support of him, claim for which he has barred from taking steps to calling the NJ case records. Again, on itna such, the plaintiff had taken a false claim that the plaintiff side had took steps as per order dated such and such, and to call for the NJ case record. The claim of the taking as order as per order dated 7/2/24 by the plaintiff appears to be false by my a learned predecessor on verification of the court fee register, as the court fee register did not reflect about the taking of any steps for calling of the NJK record. So the conduct of the plaintiff is not at all satisfactory. The present petition numbers also, the plaintiff has stated that he has received some certified copies of NJK record and yet to receive some certified copies of NJK records. The plaintiff have not enclosed any certified copy of NJK records to substantiate his claim of obtaining some of the certified copy of NJK records. Moreover, the certified copies of NJK records mentioned in pair 2 of the petition is not ready for submissions before the court. From the above, it appears that the plaintiff is only on the presumption that he shall be able to get the certified copy of the NJK records and by will submit those in evidence. Therefore, there is no explanation on the side of the plaintiff why the plaintiff failed to call for the original case records of NJ case records, though he got the opportunity to call for them. As the documents are not ready with the plaintiff and he was already barred from calling of the NJ case records by order licenses, the question following the plaintiff to submit certified copy of NJ case records enlisted in para 2 of the petition does not arise. According to the petition is rejected.
So how this impugned order is illegal or arbitrary?
Your Honor, my lord, I have enclosed the mention the which NJ case records I will going to rely.
No, you have earlier you have been given the opportunity.
Yes.
Then you failed to avail it.
My lord. Then even I am entitled to adduce the certified copies of the NJ case records.
What is this?
What is this?
What is this?
This is under order 11 rule 14 and order 7 rule 14. Production of document. Boundary dispute between the state and the state of Assam and Nagaland. Evidence of PW 9 of Survey of India being recorded. PW 9 producing certified copies of 33 maps. State of Assam seeking production of some more maps. PW 9 seeking to produce the maps. State of Nagaland objected, permission granted. My lord, in this case also, the Honorable Apex Court has granted the leave to produce those documents. The admissibility of those documents is required to be decided by the trial court at that relevant time. This is the observation of the Honorable Apex Court. And I am not seeking any other thing. I am just seeking to adduce those NJ case records, certified copies of those NJ case records, which are calling of those were barred.
Yes, any objection?
Yes, my lord, we have already filed our objection. Kindly see their petition itself. It's page 95, my lord. Page 95, paragraph 3. Firstly, in the impleadment, it is very much clearly reflected that the opportunity was granted. They failed to take the steps, and by making some misstatement in the petition that they have taken the step by verification of the court fee registered by the Honorable Trial Court, that was found to be misleading. On that count, that petition was rejected, number 1. Secondly, your lordship will kindly see page 96, paragraph 3. The NJ case records which they are seeking to rely upon, although the ordinance was called for, opportunity was given, that was closed. Thereafter, they filed a petition for relying upon the certified copies. This very statement, government made it paragraph 3, your lordship will see that on account of closure of calling of the aforesaid Miss NJ case records, the plaintiff had applied certified copies of the aforesaid Miss NJ case records. Until date, received the certified copies of the Miss NJ case records numbers so and so and so. Out of 16, they have received only few, and the rest certified copies out of the aforesaid Miss NJ case records mentioned in paragraph 2 above are yet to be received. So, my lord, this is totally a contingent petition. They are not ready with the which documents they are going to rely upon. So there is nothing wrong. No error is infirmity has been committed by the learned trial court, because there has to be specific on which document they are seeking leave of the honorable court to rely upon those certified copies. They are from their very averment in their petition. They themselves are saying that they have got only few certified copies and rest are yet to be received. So what certified copies have been received, that can only be relied upon.
But is he not entitled to exhibit those certified copies?
They are
which he
entitled,
had,
my lord, they are
already
entitled,
received?
opportunity was given, but they are not ready, they have not procured or obtained a certified copy itself also. They are not sure whether it is their possession or not, they will get it or not. Only on contingency, they cannot wait for indefinite period to prolong the litigation. Kindly see the MP note of page 107, the operating part, my lord. At best, they can rely upon what they have, whatever documents they are in possession. Upon going through the contents of the petition as well as the earlier orders of the court.
From which part you were reading?
107, second paragraph, my lord. Third paragraph. The operative part.
Yes.
Upon going through the contents of the petition as well as the earlier orders of the court, it appears that by order dated 7/2/24, the plaintiff was allowed to call for the NJ case records. But on 4/4/24, the plaintiff was directed to take steps, even after getting the opportunity to call for the NJ case records at the stage of evidence of PWs. The plaintiff did not avail the opportunity to exhibit the NJ case records in support of his claim, for which he was barred from taking steps for calling the NJ case records. Again, on 6/5/24, the plaintiff had taken a false claim that the plaintiff side took a step as per order dated 7/2/24 to call for the NJ case records. The claim of taking steps as per order dated 7/2/24 by the plaintiff appeared to be false. To my learned predecessor, on verification of court fee register, as the court fee register did not reflect about taking of any step for calling of NJ case record. So the conduct of the plaintiff is not at all satisfactory. In the present petition number so and so also, the plaintiff has stated that he has received some certified copies of NJ case records and yet to receive some certified copies of NJ case records. The plaintiff has not enclosed any certified copy of NJ case records to substantiate his claim of obtaining some of the certified copies of NJ case records. Moreover, the certified copies of all the NJ case records mentioned in para 2 of the petition is not ready for submission before the court. From the above, it appears that the plaintiff is only on the presumption that he shall be able to get the certified copies of NJ case records and thereby will submit those in evidence. So there is no explanation on the side of the plaintiff why the plaintiff failed to call for the original case records of, though he got the opportunity to call for the same, as the documents are not ready with the plaintiff and he was already barred from calling the NJ case record original. By order dated 4/4/24, the question of allowing the plaintiff to submit certified copies of the case NJ case records enlisted in paragraph 2 of the petition does not arise. According, the petition is rejected. Now, your lordship will kindly see that the matter was for evidence, it was fixed from 7/2/24. Now, more than 1.5 years has passed.
My lord, I have received now I have received the entire certified copies of those NJ cases except one. The December 2020, the serial number 1 of the application. I have all the certified copies with me.
It is not on record, your lordship.
Yes, my lord.
Page number?
Page number 96. And I'm constantly taking the seeking that whether that certified copy is ready or not, but that the office has failed to produce give the certified copies, although that applications were filed long back.
So now you have received all the
certified copies, only except one. And serial number 1. Miss J case Miss NJ case number 9628.
But those NJ cases are not part of the record.
Yes, Your Lordship.
Yes, those are part of the record. But I have mentioned the Miss NJ case record in my WS against the counterclaim also, and in my plaint also. Those
When you have received those certified copies?
after rejection of the
So whether you have made any such averment in your petition here, in this petition?
in this
That
petition
you
I have
received
mentioned.
the certified copies?
My lord.
In which paragraph you have mentioned it?
Okay.
Is it paragraph number 3?
No.
No.
It's not there, my lord. What has been stated in the petition before the learned trial court, that has been reiterated in paragraph 4 at page is the inner page 5, my lord. Paragraph 4 of the petition, revision petition.
My lord, para number 4.
Read the replica of the petition, paragraph 3 of the petition.
Till page number 6. The aforesaid Miss NJ case records and till 3/8/2024 received the certified copy of the Miss NJ case records of such and such, and the rest of the certified copies of Miss NJ as detailed in para number 3 were not received by the petitioner at that time, which were mostly received by the petitioner later on.
Which are mostly received? Mostly means?
Mostly means almost.
You have-
I have not specifically mentioned that.
Mr. Moore, better you file an additional affidavit, we will see.
My lord.
Or Mr. Moore, learned counsel for the petition, and Mr. Zalan for the respondent. List the matter on when, after 1 week?
My lord, the next date before the trial court is fixed on 23rd, my
23rd.
It can be taken up before that, 21st or 22nd.
Okay, 22nd we will take
Yes.
it up.
Yes,
ma'am.
In the meantime, you file an affidavit.
Hmm.
List the matter on 23rd, no, 22nd for further consideration, and in the meantime, Mr. Moore, learned counsel for the petitioner shall file an additional affidavit bringing on record that he has received certified copies of all those missed cases. All the 16 numbers of missed cases before this court, before next day. This record.
So note 3 for orders.
Plus,
Yes, ma'am. Notice to the respondent number 5 and 6 is completed as per office office note dated 5/11/24, and also LCR is also received, my lord. I can do this.
So you are for?
OP insurance company, lordship.
Respondent 1.
Respondent number 1.
Respondent number 1. Okay, service completed.
Yes, my lord.
Heard, Mr.
BR does, my lord.
Learned counsel for the appellant and Mr.
NM Dr. Lordship.
NM Dr. Learned counsel for the respondent number 1. Office note dated 5/11/2024 indicates that service upon respondent number 2 and 3 have already been completed. LCR has also been received. And the matter is ready for hearing. This is list the matter for hearing in usual course.
My lord, there is another analogous case. Because of we are filing an appeal on the same judgment, and there is by the owner, they have also filed another appeal, right? Appeal number 305/22. The both case cannot be tagged as together.
Okay. Mr. Das, learned counsel for the appellant also submits that. At what it says that case is pending.
My just today's matter is for enhancement.
No, that the other appeal.
Other appeal is forced to fascinate the liability to an insurance company because of that at the time of the incident, the vehicle was
No,
valid.
at what it says it is pending.
Oh, this is for also admission. For admission, yes, ma'am.
Pardon? Admission.
Yes, ma'am.
Okay. On the pair being made by Mr. Das, learned counsel for the appellant, RSSL take this matter along with MSC appeal number
305/2022.
305 of 2022.
Number 4.
Yes, my lord, in this matter, my lord, as per office note dated 9/7/2025, respondent number 5 and 6, they have received the notice.
Lordship, I have filed the appeal. The service is complete. He is appearing for the claimant, he is also appearing for the claimant, and another counsel is for claimant. To me, you are. No, you are not the appellant.
Claimant.
The appeal is filed by the insurance company. Lordship, service is complete. Only LCR is not received, Lordship. It is from Kamrup, LCR has not come. So reminder may go, Lordship. To go that side.
Artist, Mazumdar, learned counsel for the appellant, and Mr. Yes, your good name, please.
Your lordship, D Mondal, your lordship, I have filed
Learned counsel for
claim, respondent number 14.
respondent number 4. You are here.
Yes, my lord. Yes,
You-
my.
Mr. Das for respondent number
124.
124. 124. Office note dated 9/7/2025 indicates that LCR has not been received. Accordingly, it is provided SSL issue reminder to the learned tribunal for transmitting the LCR without further delay. List after.
May I please, your lordship? Your lordship, I have filed one IA for vacation of stay. Stay has been granted. It was filed way back in 19/12/2022. Till date, it has not been disposed of. There is a specific order. Your lordship peruse the last order.
I stop
Vacating, stay vacating petition.
Why?
The stay has been granted without any deposit.
Because Lordship, this is a case where one part is that fraud vehicle was as per their own document, it was planted. Secondly, Lordship, they get this government notification regarding salary that they get till the superannuation stage. So Lordship, this can be finally disposed of with the appeal, Lordship. I do not mind if it is fixed in August first week, any date.
But we have to receive the record.
Yes, so Lordship, urgent reminder, Lordship, it is from Kamrup, Lordship. MSCT 2.
August.
My lord,
Hello.
my name BR Das may be reflected in the process.
Your lordship,
Reflected.
There are 3.
your lordship, I have filed wakalatnama on the first. I filed wakalatnama without my no objection. How they can?
No, you're right. I'm waiting.
Oh,
And
acha,
there
acha,
is
Oh,
another
then it's
advocate,
no
Lordship,
problem.
Wakalatnama is filed. So this
Yes.
petition, Lordship, but they have filed, that is also doubtful, Sir, who is really claiming. That will be in the argument stage. I'll do that. Lordship. There are three different sets of wakalatnama.
Mr. Das submits.
No,
that,
it is none of your business.
No, it is my business.
No, how it is your business?
Let's see.
It is none of your business.
Places shall do the needful in this.
Shall you oblige?
Oblige.
Item number 6.
In this case, my lord, LCR called for
LCR has
received,
received
my
in
lord.
this case, my lord. My lord,
Receive.
my lord, respondent has appeared in the case, my lord. It will come for admission hearing, my lord.
Okay. Heard me, sir?
VK Barua, my lord.
VK Borua, learned counsel for the petitioner, and Mr. Gupta for the respondent. Respondent number?
One, my lord, and for one.
One.
Respondent to your lordship.
Two for respondent number 2. Then Ms. Bordolo for respondent number 2.
Service is complete, my lord.
Respondent number 2. It is submitted at the bar that service has already been completed and the LCR has also been received. And the matter is ready for admission hearing. Accordingly, it is provided that this shall be the matter for admission hearing on
28 August.
Sorry.
21st August.
Hello.
Number 7.
May I please your lordship? Your lordship, the engaged counsel who was supposed to appear due to some personal difficulties, he could not appear, lordship. So kindly the matter may be passed over for today.
Well, otherwise the matter can be taken up for hearing at any convenient date.
Okay.
Sometime a month later, maybe. Because this month I don't see, so the hearing to be taken up.
Heard Mr. Boni, learned counsel for the appellant. Then also heard Miss
P. Hajarika on behalf of
Learned-
AHMR Chaudhary.
O.
AHMR Chaudhary.
A.H. Zaman Soturi.
AHMR Chaudhary.
A.H.M.R. Soturi. Ms. Hajarika submits that the conducting counsel is out of station.
Due to some personal difficulties.
Submits that due to some personal difficulties, the conducting counsel not remain present in the court and as for listening the matter on some other day. There is accordingly allowed, Procedural is the matter. After 2 weeks.
After 2 weeks. Only in the first week of August, I may not be in town. I pray leave to be accommodated if need be.
IA was filed by you.
Yes, lordship.
That was it.
I is for lordship, modification of order dated 8/2/2024.
On 7th August. 7th August.
Obligation.
Number 8.
Your lordship, kindly pass over to the timing
Why?
on 2 p.m. because Counsel Mr. R. Goswami is in another court.
Okay.
Item 9.
The IA was filed by us seeking an impleadment in the CRP, pending CRP. In the CRP has arisen out of an order passed by Learned Labour Court. And in that proceeding, we are parties before the Learned Labour Court. Not only that, the entire exercise has begun on the basis of an information given by me. Proceeding was taken up before the Registrar of Trademarks. That was taken up at my instance. Now, on the basis of information given by me, the Registrar of Trademarks had cancelled the trade license, registration granted to the petitioner.
As against that, they have preferred an appeal before the learned labor court. And in that labor proceeding before the learned labor court, I am also a party. I have also filed my written statement in that proceeding, having been allowed by the learned labor court. Now, the CRP has been filed before this honorable court, where, my lord, I was not made a party, and I have filed an application for impleadment. On the last occasion, when the matter came, my lord, they had sought time to file an objection, but no objection has come as on date. My submission would be, your lordships may consider this and allow us to be added as a party respondent in the CRP.
Yes, Mr. Degna.
My lord, we've not filed our objection. In fact, the order by which they were implemented by the labor court, my lord, that we are challenging. So that revision, we could not file it today, my lord. So may I pray, my lord, it comes up next week. There are two IAs before your lordship, my lord. One was filed by my senior friend for impleadment, other was filed by them for vacating the stay, my lord. There they had expressed some urgency, my lord, therefore I'll not seek an adjournment on that, my lord. But insofar as my learned senior friend's application is concerned, my lord, there I'd like to pray for some accommodation because we are already challenging the other order by which they were impeded in the proceedings before the labor court.
Now, that order was passed long time back.
It was passed in May, my lord.
In the month of May.
I have.
And if that order was to be challenged, my lord, then it ought to have been done at an appropriate point of time.
Where is the bar in impleading the applicant in the CRP?
Because, my lord, if if there would not have been a challenge to their impleadment in the proceedings for the court below, my lord, I would have considered, my lord. But we are saying, my lord, in fact, this court has also observed, Supreme Court has also said, my lord, that such a proceeding cannot be drawn up at the behest of a third party, my lord. My lord, in fact, the main issue is it's a private dispute between two associations, my lord, CDAA and Assam Drug Distributors. They were an erstwhile member, my lord. We expelled them. Our information is he sided with the other group. And therefore, they filed the application for cancellation of my registration as a trade union with them, my lord. Now, my lord, the power to cancel is under section 10, my lord. This court on the earlier occasion also had reiterated that so it cannot be on the basis of a private complaint by some third party individual, my lord. And that was why the Supreme Court and this honorable court had said that such cancellation should not have been made, my lord. Now, my lord, to concede to their prayer would tantamount to saying that they have a locus or a right to question my registration.
No, they already raised this objection before the learned labor court.
Which is why I want to challenge that.
And the learned labor court has considered that and passed an order allowing me to be impleaded as a party respondent in the proceeding. Now, their only bone of contention was that I, being a third party, was not entitled to be heard in the matter. Whereas the provision that we quoted in the Trademarks Act itself, Miller, it says that the proceeding before the labor court will be governed by the provisions of the CPC. And provisions of the CPC, Miller, addition of party is one of the facets of that. Any proceeding before the labor court. So based on that, Miller, section 10 of the proceeding also, I mean, the Trade Union Act also has said that. So based on that, learned labor court has allowed that. Now, even if I am allowed to be impleaded as a party respondent here, the question which my learned friend is raising, that I, being a third party, is not required to be heard before the proceeding in the labor. Well, that the labor court will have to take a call when the matter will be heard on its merit. Well, that appeal is still pending. It is not decided as yet. In this miscellaneous proceeding, that question cannot be gone into. The limited question is only that whether my impleadment in the proceeding will cause any prejudice to him. My impleadment is only for the purpose, I am seeking impleadment only for the purpose of bringing to be before your lordship the fact that why and how the information was given to the Registrar of Trademarks and how the Registrar of Trademarks has, Registrar of Trade Union has caused the inquiry and cancelled the certificate. And thereafter, my lord, I also filed a petition before the learned labor court. When he carried on the cancellation before the learned labor court in an appeal, I filed an application saying that it was on the basis of my information provided, and therefore I may also be heard because that will help the proper adjudication of the matter. Learned Labour Court has allowed that. But before that could be done, my lord, this revision petition was filed. So naturally, I was not made a party here. Now I want that, please make me a party here.
My simple prayer today is, I can file the revision against that order of impleadment by tomorrow. So your lordship can have it next week along
No,
with
that is also, my lord, that is also a question whether against an order passed by the Labour Court, a 227 petition will be maintainable or not. Because in this CRP, my lord, I understand the government has also filed an application for vacating the order of stay, principally on the ground that the 227 petition is not maintainable against an order passed by the Labour Court. Well, that is how I could I do not know how the arguments will be made, my lord, but this is one of the premise, my lord, on which this application has been filed, which is also there on your lordship's board today. So whether 227 petition will be maintainable to challenge an order of impleadment, my lord, that will be another question. But that cannot prevent the honorable court from passing an order in my favor today. If you file an application tomorrow, and if you succeed in that application, then naturally as a consequence thereof, my impleadment will go. So that cannot be a bar for his contention that he will file an application challenging the order of impleadment. That by itself cannot be a bar to consider my petition.
I'm not urging that there is a bar. I'm only seeking an accommodation, until next week or maybe day after tomorrow. I'm not saying that his application cannot be considered. I'm just saying, since we are filing a revision tomorrow, let it be considered together, my lord. Because that is the precise question, my lord. Ultimately, my lord, my registration is with the Registrar of Trade Unions, my lord. Someone files an application, my lord. He's a disgruntled member, my lord. He was dismissed from his membership was cancelled. So out of vengeance, he files an application, my lord. For the purposes of exercising section 10, my lord, this court on the previous occasion had made that very clear that third-party intervention, on the basis of third-party intervention, you're not supposed to cancel, my lord. Now,
That's all right, but today we are on.
Today, I'm just seeking an accommodation, my lord. I'm not making
My lord,
any
my
argument
lord,
that that I will make, my lord, once the revision is on board. That's all I'm saying.
His submission impels me to say a little more, my lord. The entire thing is designed in a way so that the appeal before the Land Labour Court is not decided expeditiously. They have already taken more than 4 adjournments in filing their affidavits. 4 adjournments have been granted to them, my lord. They are not coming before the court clear. They just want to delay the matter because now your lordship has granted them an order of stay in the CRP. And in the garb of that CRP, my lord, they are continuing with the registration. They want to, they know for sure that unless and until there would be an order from your lordship, my lord, they would not be able to continue under the registration because the registration is cancelled. And what they have done, my lord, in a case where the registration has been cancelled, they have preferred a revision petition before your lordships and asked your lordship to inject life in a dead body. Now, because of the interim order granted, my lord, they are merrily continuing with the registration and dragging the matter before the Land Labour Court. That is the entire design. Otherwise, my lord, it's an open and shut case. Their entire case before the learned Registrar of Trademarks was that there were 2 resolutions. They have failed to substantiate that. They have also been failing to substantiate that before the Learned Labour Court. And by protracting litigation, my lord, tomorrow they will come with a revision. Thereafter, they will come with another petition asking your lordships to stay the proceeding before the Learned Labour Court. The object of the Labour Court is not that you will keep on dragging the matter for times to come, and on that pretext you delay the disposal. My submission is that, my lord, whatever petition he may file, that is his right, he can do that. But if he succeeds in his petition, in that case, I will lose it. That cannot be, the mere fact that he will file a petition in future, that will not be a ground for disallowing my petition today. Your lordship may allow this application. They have been given sufficient time to file an application. Ultimately, it will be your lordship's order. That cannot prejudice him from filing a petition subsequently. And as a matter of fact, my lord, as on date, I am one of the parties before the Learned Labour Court.
Let us allow this application
Then your
today.
lordship will allow me to argue, my lord, and argue without an affidavit. My lord will kindly have the Trade Unions Act.
We are not on the merit of the.
But his locus is.
Petition,
My
but
lord, what is
on
this
this
Impleadment
petition.
Yes, my lord. I'll argue on impleadment only because I am treated as, even as per the CPC, my lord, I am treated as a plaintiff. Now, the Supreme Court has time and again said that a plaintiff cannot be compelled to file a implead a party against his wishes, since I am the dominus litis. Secondly, my lord, if your lordship may kindly allow me, I'll just. My lord, the entire proceedings arises out of this power, which is section 10 of the Trade Unions Act. My lord. If I may read this, my lord, a certificate of registration of a trade union may be withdrawn or cancelled by the registrar. On the app.
No, Mr. Decker, we are not hearing the civil revision petition.
My lord, I'm just on his impleadment. My lord. I'll not argue anything else, my lord. Just on his impleadment.
So then why you are arguing on cancellation of the registration?
Because my lord, interpreting this section, Supreme Court said that third party application is not permissible. Now, if third party application is not permissible, my lord.
No, that's all right, but can we hear the matter without impleading him as a party?
Yes, my lord. That is my argument. Because, my lord, for impleading, your lordship will exercise Order 1, Rule 10, my lord. Supreme Court has now said that ultimately, if I don't concede, since I am the dominus litis, my lord, your lordship has to record a categorical finding that your lordship will not be able to effectively adjudicate the proceeding in his absence, my lord. So, therefore, my lord, he must show a direct and subsisting interest, my lord. Now, based on these two grounds, my lord, first of all, he has to show a direct and subsisting interest, because ultimately this is a proceeding between the trade union, registrar and me, my lord. This is ultimately a function of the public function. Now, the question is whether a third party, because he may have some grudge or interest or whatever against my registration as a trade union. Now, in that application, therefore, my lord, he has to show that he will be prejudiced if my registration as a trade union continues. Because ultimately, your lordship will exercise Order 1, Rule 10 too. Now, if your lordship passes this order under Order 1, Rule 10, holding that he is a necessary party to these revision petition, my lord, my difficulty, why I'm urging your lordship to hear me, is because of this, my lord. Today, if your lordship impleads him as a party, my lord, your lordship has to return a finding that he is a necessary party to these proceedings. The moment your lordship says that, my lord, my challenge to the other order, where the labor court had said that he is a necessary party, which finding I'm challenging, my lord, then it will obviously have effect on this. So, my lord, if your lordship kindly bears with me, my lord, your lordship can either hear it, therefore my first submission was, your lordship will either hear it together, so that your lordship can decide whether he has any locus or not. Secondly, my lord, if your lordship is taking it up individually, my lord, your lordship will consider my arguments regarding this, my lord. And thirdly, my lord, subject to what my senior says, my lord, if your lordship impleads, your lordship will kindly observe that this particular order of impleadment would not prejudice me in challenging the other order. Then perhaps we can, because ultimately I have to challenge that order, whereby he.
Whether that kind of conditional impleadment order can be passed by this court.
My lord, we can say, because that revision petition is not even under challenge. Not even before your lordship. Because ultimately, if your lordship passes this order, it will be an endorsement to the other order.
How?
Because if your lordship, in order to
other civil revision petition is yet to be filed.
No, my lord, I'm just saying, if your lordship says today that they are a necessary party to the revision petition itself, my lord, then obviously it will definitely mean that they are necessary parties before the tribunal as well, my lord. Which is which is why the difficulty, and therefore I wanted to say that let that come on board. So now whatever finding your lordship will record is bound to be binding upon all of us. So that is why. Anyway, my lord, section 10, if your lordship sees, A is on an application of the trade union to be verified in such manner as may be prescribed. So I, as a trade union, can myself apply, my lord. And B, if the registrar is satisfied that the certificate has been obtained by fraud or mistake, or that the trade union has ceased to exist, or has willfully and after notice from the registrar contravened any provisions of this act, or allowed any rule to continue in force which is inconsistent with any such provision, or has rescinded any rule providing for any provision for which is required by section 6. If the registrar is satisfied that the registered trade union of workmen ceases to have the requisite number of parties. Now, so section 10 conceives of 3 ways where my trade union registration can be cancelled. It either can be on my own application, where I said I don't want to continue as a trade union. It can either be suo moto by the registrar on 2 occasions. One, if it finds that I have played fraud or etc. And third is when I don't have the requisite number of parties. A and C is not even applicable here. What remains is B, if the registrar can exercises that power suo moto. Now, interpreting this section 10, the Supreme Court in R.G. D'Souza said that this contemplates only 3 mechanisms. Now, out of these 3 mechanisms, para 19, if your lordship takes up. Because it's a question of locus ultimately.
No, if we go to the root of the matter in this impleadment petition, it may cause prejudice to the party.
True, my lord, which is why I was trying to say, my lord, that it can be taken up Friday, my lord, if I file it tomorrow, my lord, or maybe Monday, my lord.
Anyway, you continue with your argument.
Yes, my lord. Now, my lord, para 19, my lord. As per section 10 of the Act, the certificate of registration of a trade union may be withdrawn or cancelled by the registrar of trade unions, either on an application of a trade union inviting the intention of the registrar of trade unions, or the registrar may suo moto take cognizance under the said section. There is no mention, my lord, this is important. There is no mention in the said provision about the cancellation of registration of the trade union on an application by any other person. Well, the precise thrust of the argument in this application, in this prayer for impleadment is that I have a right to participate in the proceedings because it has arisen out of my application. Now, if the provision does not even conceive of an application, my lord, then the question would then arise whether he can be said to be a necessary party or not. Because for exercising order 1 rule 10, if I am as a plaintiff am not willing to implead him as a necessary party, my lord, then he has to show a direct interest. So if I may move on to the other judgments on 5.2, if your lordship takes up.
Pardon?
5.2, para 5.2.
Yes.
Now here they were considering in the context of a suit for a specific performance, my lord.
Yes.
An identical question came to be considered before this court in Kasturi, and applying the principle that the plaintiff is the dominus litis in the similar facts and circumstances of the case, the court observed and held that the question of jurisdiction of the court to invoke Order 1, Rule 10, to add a party who is not a made party in the suit by the plaintiff shall not arise unless a party proposed to be added has direct and legal interest in the controversy involved in the suit. It is further observed and held by the court that two tests are to be satisfied for determining the question as to who is a necessary party. The tests are: one, there must be a right to some relief against such party in respect of the controversies involved in the proceedings. I pause here, Malab. I have not claimed any relief against them, Malab. My only grievance is, why did you cancel my registration? And I have nothing to do, I have no grievance or prayer insofar as Mr. Abedullah is concerned, who is the applicant. Two, no effective decree can be passed in the absence of such party, my lord. I pause here again, my lord. Can it be said that your lordship or the tribunal for that matter will not be able to pass an effective order as to whether the cancellation of the trade union registration should be stayed or not, whether it should be set aside in the absence of Mr. Abedullah? So these two are the questions, my lord. My lord, I move on to 5.3, my lord, because the rest are concerning the proposition regarding specific performance. In para 15 and 16, this court observed and held as under.
Para number?
5.3, my lord, right below.
Yes.
As discussed herein before earlier, whether respondent number whether respondent number 1 and 4 to 11 were proper parties or not, the governing principle for deciding the question would be that the presence of respondent number 1 and 4 to 11 before the court would be necessary to enable it effectually and completely to adjudicate and settle all the questions involved in the suit. As noted so and so, in a suit for specific performance, the issue to be decided is the enforceability of the contract entered into between the appellant and the respondent number 2, and whether the contract was executed by the appellant and the respondent number 2 and 3 for sale of the contracted property, whether the plaintiffs are ready and willing to perform their part of the contract, and whether the appellant is entitled to a decree for specific performance against respondent 2 and 3. It is an admitted position that respondent 1 and 4 to 11 did not seek their addition in the suit on the strength of the contract in respect of the suit for specific performance of the contract for sale has been filed. Admittedly, they base their claim on independent title and possession of the so-and-so. It is therefore obvious, as noted here earlier, that in the event of respondent 1 and 4 to are implemented, the scope of the suit of specific performance shall be enlarged from the suit of specific performance to a suit for title and possession, which is not permissible under the law. So, my lord, coming back to the facts of this case, my lord, the only issue before it is I am a body of individuals, my lord. He is no longer a part of that body, my lord, because he has long been expelled, my lord. Now, my registration has been cancelled by the registrar under section 10 of the Trade Unions Act. The registrar of the trade union, registrar of trade union maintains, my lord, that exercise has been done under subsection B. Subsection B, Supreme Court has said, in fact, I'll show the other judgment in the same proceedings, my lord, has said that subsection B is a suo motu power. And the moment it becomes a suo motu power, my lord, it cannot be conceived that it can be on the basis of an application. Now, my lord, coming back to the two tests for their impleadment under Order 1, Rule 10, my lord. Firstly, I have not claimed any relief against them. I am the dominus litis.
No, you are repeating the same thing.
I'll move on to the next point. Now, if your lordship will kindly have the order passed by this honorable court in the other CRP, my lord, which your lordship finds at page 136.
In the CRP?
Yes, in the CRP. .
Yes.
My lord, we'll have para 16 onward at page 145.
Yes, para 16.
As per section 10, the certificate of registration of a trade union may be withdrawn or cancelled by the registrar of trade union, either on an application of a trade union inviting the attention of the registrar of trade unions, or the registrar may suo motu take cognizance under the said section. There is no mention in the said provision about the cancellation of the trade union on an application by any other person. The said section permits the authority to cancel the registration of the trade union if it is obtained by fraud or mistake, but does not permit the authority to cancel the certificate of registration if the same is granted by mistake due to incorrect assessment or non-application of mind or mechanical act on the part of the authority. Even for the sake of argument, it is accepted that the mistake is on the part of the trade union and in the opinion of the registrar of trade union in exercise of his powers under section 10 of the act cancels the certificate of registration of the trade union, then it must be preceded by an inquiry followed by show cause disclosing grounds for initiating action so that the same can be answered by the noticee upon effectively. Section 10A needs to be read with section 10B, which speaks about the satisfaction of the registrar about the validity of the certificate. When the registrar forms an opinion to exercise suo motu powers, it must be preceded by an inquiry, maybe preliminary in nature. He has to record satisfaction before initiating action, cancellation, or registration of the union, followed by show cause notice disclosing the grounds for action so that the same can be effectively answered by the noticee union. Now, in so far as the order is concerned, well, they base their right to get impleaded, my lord. If your lordship comes back to the order 2041, my lord, in IA 2041.
Yes.
At page 45, my lord.
Yes.
My grievance basically was the third paragraph. The applicant is an interested party in the proceeding of the case as he has knowledge of various activities of an appellant association which would assist the court in adjudging the instant appeal. Hence the application. My lord. Now, my lord, that in my respectful submission was not even the test, my lord. He had a vital information or he has vital information. Tomorrow he can be a witness, my lord. To deviate from the rule of dominus litis, my lord, and to say that we will implead him against your wishes, my lord, the test of necessity was not even done, my lord. So, therefore, my lord, I'd say, my lord, that in the and this proceeding, the current CRP is filed for stay because the stay application was rejected by the tribunal. And this application is only limited to that aspect whether there should be a stay of the cancellation order passed by the respondent number 1. And at that relevant point of time, he was not Mr. Abedullah was not even a party before the proceedings. So therefore, my lord, for a third party to come and sort of drive the entire proceeding, since it is not conceived of under section 10, he has no direct interest. Since he has no direct interest, he cannot be said to be a necessary party, and there can be an effective adjudication even in his absence.
My lord, only one reply to his submission, Lord. Order 1, Rule 10 visualizes two kinds of parties, necessary party as well as proper party. Even if, my lord, I agree to his submission that I am not a necessary party, your lordship can still implead me as a party in the capacity of being a proper party, so far as the proper adjudication of the matter is concerned. Order 1, Rule 10(2) says it is up to the discretion of the court. If lordship feels that my appearance in the proceeding will be of help in proper adjudication of the matter, I can be added as a proper party. not even as a necessary party. This is first submission. Second submission is that, my lord, why I am saying that I may be added as a party, proper party for effective adjudication of the matter. If your lordship will kindly take up my IA, paragraph 3 at page 4. This has been the very case of the applicant right from the initial stage. Well, the registration that the association has taken out, that was done by manipulating my signature. And since my signature was manipulated, it was misused, and a forged memorandum of minutes of proceeding was drawn, and on the basis thereof the certificate was taken out. I filed an information before the learned registrar of trade union. So it is me who knows how my signature has been manipulated or how it has been misused. Therefore, I said before the learned labor court that my presence before the court will help the court in deciding the matter in the right perspective. That was my case. I may not be a person directly interested as he is projecting. My learned friend is projecting that I cannot have a direct interest in the matter. Even if I cannot have a direct interest in the matter, I can still be of some use. He has said that I can be regarded as a witness to the proceeding. Now, if I am regarded as a witness to the proceeding, my lord, then also I can be considered, without considering me as a proper party, I cannot be made a witness in the proceeding. So even if my learned friend's submission that I can be cited as a witness in the proceeding is accepted, my lord, in that case also, whom will you call for as a witness? Somebody who has a relevance, who has a connection with the subject matter in dispute, he can only be a witness. So even if he exceeds to the point that I can be a witness to the proceeding, my lord, that is enough to say that, my lord, I am a proper party, at least, even if I am not a necessary party. And in paragraph 3, your lordship will kindly see 4th sentence from the top.
Paragraph number 3.
Paragraph number 3, that the applicant, may I read it, lordship?
Yes.
The applicant most respectfully states that when he eventually found out that the opposite party so-and-so had not been registered under the Societies Registration Act, but was registered under the Trade Union Act so-and-so, and the signature of the applicant given in the meeting dated so-and-so at hotel so-and-so was misused by the office bearers of the opposite party petitioners association, he filed an information before the Registrar of Trade Union bringing into forth the illegalities committed by the members of the so-and-so association and request that the registration of the so-and-so be cancelled and their name be struck off from the register. Now, my signature is misused. Who else can say it better than me? So naturally, my presence in the proceeding will be of very relevance for proper adjudication of the matter. And considering this, the learned tribunal, learned labor court had allowed me to be impleaded as a party. So far as the question of impleading necessary party is concerned, that rests on a test of necessity and all. That I am not in disagreement with. But the question is that whether I am a proper party or not. Even if I am a proper party, it has to be allowed.
Okay.
Here, I am the registrar of trade union.
Okay.
It is my order which is under challenge in the first form. Now, I'm just
Mr. Chakraborty, we are not on the CRP.
No,
We are on the
I
impleadment
just like to
application.
assist your lordship to place certain basic facts which resulted in all this action. What happened, my lord? The petitioner obtained registration under the Trade Unions Act. By enclosing a minute submitting, which is very essential to obtain registration under the Act, there has to be a resolution of the members that we are obtaining, going for a registration under the Trade Union. That minutes of the meeting with signature of the persons present were given to Register of Trade Union. Accordingly, registration takes place. Then comes Mr. Abedullah. He, for the first time, has brought to the notice of the registrar, you see, that the minutes which was annexed to obtain the registration was a manipulated document. The meeting was held to
get the association registered under the Societies Registration Act. Now, having come to know all these things, placed by Mr. Abedullah, we issued a notice to the association for cancellation on the ground of fraud. It is not the argument advanced by the petitioner that at the instance of Abedullah, the registration was cancelled. It is not. It is cancelled by issuing notice on the ground that you have manipulated record to obtain the registration. Now, my lord, interestingly, they have examined.
You got that information from Mr.
Abedullah.
Then
They have manipulated the record. Now, Abedullah has also placed the minutes and the application obtained from RTI regarding their application before the Register of Trade Union. If your lordship takes up my eye cancelling the, for setting aside this interim order, this is also on board, my lord. Lordship will have certain interesting facts.
it is I number 2182.
2182. If your lordship comes to page 18, now repeatedly even the labor court directed them to produce both the minutes, because interestingly on the same day 2 meetings were held. All the signatories in the meeting appears to be the same person and their serial numbers are same. In one meeting it was resolved that it should be registered under the Societies Registration Act, and the other meeting it is under the Trade Unions Act. Now, my lord, what they have done, they approached the Register of Societies earlier. When they could not get that registration for reasons that maybe the secretary was having a criminal case and all, they U-turned and manipulated the minutes by maintaining the signatures of all the persons and got the registration on the Trade Union Act. This is where they have done the fraud. Now, if your lordship comes to page 18, lordship will see it is a meeting held on 12/8/2018. One, Nator Lal, President, Agarwala President, Dilip Chandra Goswami, Secretary. So it was resolved at page 19. Your lordship will find at point number 8, it is resolved that application for registration under the Trade Union Act will be made. Now, this is 12/8/2018 resolution for registration under the Trade Unions Act. Now, in the next page, your lordship will find the signature of Abedullah at serial number 4. This is Mr. Abedullah, Muhammad Abedullah. Now, same day, same meeting, if your lordship comes to page 23. Same day, 12th August 2018. And lordship may come to page 24. Meeting also adopted a resolution to register the society under the Societies Registration Act. Here, Agarwala is the president and Mr. Jitu Bormon is the secretary. Now, my lord, same day, 2 different meetings, and the signature, if your lordship comes to page 26, same Muhammad Abedullah signature finding at serial number 4. So the page 26. Now, assuming, my lord, there were 2 meetings. Page 26, again Abedullah serial number 4 signature. This is what we got from Mr. Abedullah. Now, my lord, assuming, my lord, both the meetings were held. But why they will first approach if the resolution was to get it registered under the Trade Unions Act, then they should have immediately complied with the resolution and applied for registration under the Trade Unions Act. Meeting of 12/8/2018, they approaches the Register of Society in 2018 November. No, please, please.
Just for a clarification, is 20812 being placed because this has not.
No, I'm not placing, I'm just,
Is it impleadment or not?
I'm just placing the basic facts for a lordship to take a overall view, how and everything has happened and how everything unfolded. Now, they files the application for registration before the Register of Societies on 5/10/2018. Lordship has seen 12/8/2018 resolution. You go and apply, President should apply before the Register of Societies. They applies before the Register of Societies on 5/10/2018. Did not succeed. Then they applies for registration before the trade union on 27/2/2019. By manipulating those documents, maintaining the signature sheet, but they have changed the resolution part. That is why, my lord, the labor court time and again directed them to produce both the original resolutions. If they succeed, even before your lordship, today, if they succeed to bring both the original resolutions, nothing remains. I'll just say that order was wrong. Let them produce it before your lordship also. If there are two resolutions, there has to be two resolutions in original with original signatures of all the persons attending. They could not. They have examined 10 or 12 witnesses before the labor court. Till now, no original document. We are waiting. So they are dragging the matter with the
And
stay
they have
order.
given a
Please,
list of
please,
27 witnesses.
Please. Now, my lord, this is how Abedullah comes into picture. And every time a projection is being made, that it is at the instance of Abedullah, who is a disgruntled member. Now, if this is the fact, then why are they not saying when was Abedullah removed from the role? It is only after he files this application. Application to bring the fact. What he has done, he has brought the truth before the authority, saying that you have done a wrong thing under the influence of a fraudulent document. And the law says, under Trade Union Act, if the registration of union is obtained by fraud, the registrar has the right to cancel. Of course, by giving a notice. Here also, a notice was given. They were asked to explain about this. And the plea they have taken, that I will also take your lordship to their plea before the registrar. What was their actual case? What they actually contended? How they have explained these two meetings?
So, Mr. Chakraborty, this application is listed for the first time today.
Yes. So, and they have obtained a stay order from your lordship. The earlier stay was given, it was an ex parte stay, where they prayed before the labor court saying that we have a trade union meeting. For the time being, if your lordship takes up this, because it will give your lordship a broad picture, how on earth they are proceeding. They are the member of a organization, All India Chemist and Druggist Association, which is a registered society. That is also annexed. And if your lordship takes up my IA page 52, they are the state members of All India Organization of Chemists and Druggists. So that is a registered society at page 52. It is a registered society. And they made a submission before the labor court at the time of moving the appeal that we have a meeting, trade union meeting. That is why it should be state. And based on that, labor court granted them. Then after some time, when many things happened, initially there was a stay order, they moved, certain developments took place. Now, if they are the member of a society, their parent body is a society. So if your lordship comes to page 53, ordinary member is to be each member will have to submit the registered memorandum, page 53, membership. So to be a member of a society, you need not be a registered trade union. Trade union is something different. Your parent body, now your lordship is aware, there are various unions, they have a central union. Like Assam All India Trade Union Congress, their Assam Cha Mazdoor Sangha is the trade union, and they are registered to All India Trade Union Congress. So our trade union is always a member to a parent trade union. First time I am coming across a trade union who has registered them as a trade union is a member of a society. So that society, to be a member of the society, you do not require a trade union registration. That is why, my lord, this association, the whole process, everything, they could not obtain the registration under the Societies Registration Act because of certain factors. Immediately what they have done, they work out this process, change, even they change same day. Some strange things are happening. Same day, 2 meetings. In one meeting, Mr. Jitu Bormon is appointed as the secretary, and the minutes of that meeting, as per that minutes, the association ought to have been registered under the Societies Registration Act. The same day, another meeting, a different person is shown to be the secretary. Why? Because Jitu Bormon had a pending criminal case, and that prevented them from getting registered on the Societies Registration Act. So this subsequent meeting was never held. It was only the minutes got changed. And if that is the case, this is a registration obtained by fraud. And who has brought this notice to who has brought all these things to the notice of the Registrar of Trade Union? It is Mr. Abidullah, because he was a person who not only was a member of that association, he was a person present in the meeting. And it is his case that we had never gone for a meeting for registration under the trade union. It was only a resolution adopted to register it under the Societies Registration Act.
Okay.
So, my lord, this is how everything unfolded.
Okay.
Now, there is a stay application. I have filed an application, this 2182, for setting aside or vacating the interim order that was passed by your lordship. Because the stay of the registration was vacated by the Labour Court. Against that order, they have filed the present CRP, and your lordship was pleased to pass an order on 26/3/2025, granting a stay of the cancellation of registration.
Okay. Let notice go in your petition.
My lord, here this application was filed on 26/6/25. Copy was served upon them on 24/6, and they have not filed any reply. And my lord, there was original order was a stay up to a particular date. When that their IA was listed, that was extended, and the stay is up to today. So for extension of the stay, lordship will definitely would like to have a look at my stay application petition, because mechanically in that case, lordship, perhaps your lordship will not like to extend the stay on the grounds that how everything unfolded, how they had initially obtained the registration.
No, Mr. Chakraborty, I have to give an opportunity to them to respond to your application.
My lord, they have chosen not to respond.
This interim will continue.
My lord, they have chosen not to respond till now. The copy was served in advance.
No, even then the matter is listed today before this court.
They have not, with all respect, my lord, they have chosen not to respond till now.
We'll see. Heard Mr. Chakraborty, learned counsel for the applicant. This application, it is interlocutory application is prepared by the applicant. Oh.
Madam, 2041 is my IA for Impleadment.
2182 is there. 2182.
No. This filed by him.
Oh, that is 2182.
2182.
Yes.
That is 2182.
Yes. For vacating, stroke modifying the interim order dated 6/3/2025, passed in CRPIO number 85 of 2024. Let notice be issued to the respondent, to the opposite party. However, no formal notice is required to be issued since the opposite parties are represented by Mr. Bedi Deka, Learned Counsel for the Learned Counsel. Would you like to file an objection?
I can.
No objection.
No, I'll file, I'll orally argue.
You will orally argue.
No, everything is on record. I've also brought in, he's also brought in on the.
Okay.
Let
Then
it,
when
let it come up after the concept, because if my senior friend's party is added, my lord, he can also participate, depending on that.
okay.
In that case, since your lordship has already issued notice and he is not objecting or filing any reply, let it be fixed next week for hearing on 24th.
24.
24th, my lord, I'll have some difficulty.
No, for
Of
my
course,
stay,
yes,
this is-
his
this-
application can be fixed on that day.
Because in my, since I have come for a,
Mr. Doctor, in the event of your impleadment,
My lord,
Sorry for.
my lord, if your lordship
If
is,
your lordship takes up the entire matter itself with. Oh,
my lord, what I may suggest, my lord, if your lordship takes a decision on my impleadment application, he's,
today, no, we definitely will take a call on today.
yes, sir, his application for vacating stay can be heard even in my absence, my lord, because that is between.
No,
him and-
you have no objection then.
No, I have no objection if the stay is
Okay.
vacated.
Mr. Chakraborty, when can it be listed?
24th.
28th or 24th.
Nah, thank you.
28,
No, in that case, let it be on a hearing day, my lord, 29th.
29. Okay, all right.
No, no, hearing day.
All right. In the impleadment application, we'll pass the order today. We'll pass the order today in the impleadment application.
31st, can it be 31st?
31st. Okay.
Deeply obliged.
Obliged.
32.
Wait, this is your lordship. Lordship, this is a delay petition listed for the first time. Delay of 15 days, lordship. I think notice will go, lordship.
Miss R.D. Mazumdar, Learned Counsel for the applicant. This interlocutory application is preferred by the applicant. New India Assurance Company Limited for condemnation of delay of
15 days.
15 days in filing connected appeal against the judgment and order. Judgment and award dated 24/7/2024 passed by the learned member, Motor Accident Claim Tribunal, number 1, Kamrup Guwahati, in MSC case number 1060 of 2018. Let notice be issued, returnable in 4 weeks, that be taken by registered post with KD and also by usual process within a week from today. List of proposals.
Highly obliged.
Let us for hearing. Item numbers 10 and 11, partner matter.
On the last occasion, I have argued and I have placed on record a judgment with regard to the proposition that Order 39-2A is quasi-criminal, which your lordship had. The proposition slate and 2 judgments I have placed on. Is there on the record. I have just seen. Lordship, one is from Punjab and Haryana High Court and one is from the Uttar Pradesh High Court. In the Punjab and Haryana case, your lordship, Avtar Singh versus Balkar Singh, your lordship may kindly peruse para 4 at the bottom, your lordship.
Yes.
It cannot be disputed if your lordship finds the last 3 lines. It cannot be disputed that proceedings which are initiated under Order 39-2A are quasi-criminal in nature. This is one And the other one, your lordship will find in the Uttar Pradesh High Court's case, Savitri Devi versus Civil Judge Senior Division. Here, your lordship will be kind enough to come to, there are 26, your lordship. The last page. In view of the above discussions, one reaches the inescapable conclusion that the proceeding under Order 39-2A are quasi-criminal in nature and meant to, this is, your lordship had asked me specifically from where I was arguing with regard to this. So your lordship had asked me to place two judgments in support. And I had concluded my argument on the last occasion. Apart from these two judgments, your lordship had specifically asked me to produce in support of my contention, your lordship.
Yes, Mr. Som.
Lordship, on that day, my senior already argued. Argument was concluded on both sides, Lordship.
Acha.
Your lordship had only asked me to, given me time to produce this. So on the very next day, I had filed it because.
We reserve the order. Heard Mr. Business, Learned Counsel for the. It is only in the application.
Only in the violation application.
Only in the application, your lordship. The main matter may be listed for hearing, your lordship, because everything is over. The RSA filed by.
When?
Any day, your lordship may, please.
August last part, Lordship.
August last part.
Lordship.
26th August.
One is RSA 58 and one is 60, your lordship. One is against their rejection of their counterclaim and one is in allowing our suit, your lordship.
No, it is IA in the violation of the injunction order. I number 2546.
2546, Lordship.
2546. Heard Mr. Business, Learned Counsel for the applicant, and Mr. Whose name is to be reflected, your name or his senior name?
Senior name may be reflected.
Mr. Saho.
Chauhan, Lordship. H. Chauhan.
Chauhan, okay.
H.
That's
Chauhan.
Chauhan, Learned Counsel for the response. Argument concluded or the result. In RSA window, as agreed by learned advocates of both the parties, rest the list of member on 26 August for hearing.
Obliged.
Obliged, Lordship.
Obliged.
Number 12.
My lord, the other side is not present. This is the second appeal. I don't care.
Who was appearing for the respondent?
Huh? In one occasion, Mr. Sharma appeared, I'm told, my lord. But
This is of 2011.
that's right. But Mr. Sharma's name I find is not there, my lord. Perhaps he missed it because Mr. Sharma, Ki Sharma, he was the earlier the Judicial,
S. Sharma,
maybe, my lord.
they Hussein, D. does. Let us do one thing. The
What?
meantime, Courtmaster will contact this council. We will take it up at 2 o'clock.
Lord.
Item number 14.
রিমান্ড করিব নাকি রিমান্ড করিব কইলে আমার একটা জাজমেন্ট আছে প্লিজ লর্ডশিপ দিস ম্যাটার ইজ এ miscellaneous first appeal. So lordship, actually what happened in this we challenge the order of the RCT, lordship, Railway Claims Tribunal. On the last occasion, opposite party, actually my learned friend Rothi, he was represented. So he submitted that this matter also may be remanded to the trial court again because it was heard only single judge, lordship. According to the Railway Act, there should be one technical member and one judicial.
Acha.
But in the similar judgment, lordship kindly and the last occasion, one judgment was passed by this Honorable High Court, lordship.
Correct.
Single democratic decision, High Court order, it was itu more photo দিবেন যদি ফটোটা ওকে চেঞ্জ করবেন আমি কি একটু ফটো দেখাচ্ছি তুমি ফটো দেখাবো আর একটু বেশি সেটা হাইকোর্ট জাজমেন্ট
So this decision is available with you? Union of India versus
yes
minor.
yes lordship I have this
You have.
yeah and accordingly Supreme Court also
So your submission is that the matter shall be remanded to the learned claim tribunal.
lordship
Yes, any objection?
Lordship, first of all, Lordship, this impugned judgment was passed by the Honorable Chairman of the Railway Claims Tribunal, Lordship, of Principal Bench at Guwahati, Lordship. So this judgment was passed by the Honorable Chairman. And as per Section 4, Lordship, the Chairman has the in-hand power to adjudicate the claim application.
Sitting singly.
Yes, Lordship. Lordship may kindly see Section 4, subsection 4 of the Railway Claims Tribunal Act 1987. The judgment which the learned counsel have relied upon, Lordship, that judgment, impugned judgment of the Railway Claims Tribunal was passed by the member technical of the Railway Claims Tribunal. So in that order, Lordship, the Honorable Court held that the single member technical cannot adjudicate the claim singly, Lordship. That is the case. Now here, Lordship, this judgment was passed by the Honorable Chairman of the Railway Claims Tribunal. Railway Claims Tribunal Act 1987.
Section 4.
Section 4, Lordship.
Yes.
May I read, Lordship? Composition of Claims Tribunal and benches thereof. The Claims Tribunal shall consist of a chairman, 4 vice chairmen, and such number of judicial members and technical members as the central government may deem fit, and subject to the other provisions of this Act. The jurisdiction, powers, and authority of the Claims Tribunal may be exercised by benches thereof. 2. Subject to the other provisions of this Act, a bench shall consist of 1 judicial member and 1 technical member. 3. Notwithstanding anything contained in subsection 1, the chairman A may, in addition to discharging the functions of the judicial member or the technical member of the bench to which he is appointed, discharge the functions of the judicial member, or as the case may be, the technical member of any other bench. B. May transfer a vice chairman or other members from one bench to another bench. C. May authorize the vice chairman or the judicial member or the technical member appointed to one bench to discharge also the functions of the vice chairman, or as the case may be, the judicial member or the technical member of another bench. 4. Notwithstanding anything contained in the foregoing provisions of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers, and authority of the Claims Tribunal in respect of such classes of cases or such matters pertaining to such classes of cases as the chairman may by general or special order specify. Here, Lordship, the chairman has the power to appoint single member also by passing any general or special order. But in the present case, Lordship, the chairman itself, he himself passed this judgment and he has the in-hand power to deal the case, Lordship. So here, by emphasizing subsection 4 of section 4, Lordship, the chairman has the power to appoint any other member authorized by the chairman or Lordship to function as a bench, Lordship. Now here, my lord, the chairman himself, Lordship, passed this judgment. So in this regard, Lordship, my submission would be that the chairman has the power to deal this case, Lordship. So in this regard, Lordship, that judgment is not applicable, particularly in this case, Lordship. This is not applicable. If the judgment is passed by the member technical or member judicial, then Lordship, the judgment can be applicable. But here, the judgment itself passed by the Honorable Chairman of the Railway Claims Tribunal, Principal Bench, Lordship. So my submission would be, Lordship, because this is a matter of 2013, Lordship. And after passing of 12 years, Lordship, after a decade, Lordship, if the matter is remanded back, Lordship, long time, Lordship, has been passed, Lordship, and delay is already there, Lordship. If Lordship insists, Lordship, then Lordship can hear this matter, Lordship, because it's the claim application was filed in the year, Lordship, 2012. And the judgment was delivered in the year 2016. And in the court, in the Honorable Court Lordship, this appeal is of 2013. So Lordship, long time has been passed, Lordship. So my request will be, Lordship, may kindly hear this case on merit, Lordship.
Yes, Mr. Day.
Lordship.
So what is your response to the submission made by Ms. Soma?
Actually, in the High Court's judgment, which is challenged before this Supreme Court, already before the Lordship, there is not any specifically mention that the only chairman can exercise.
No, the problem is that in the judgment,
that is being challenged before this High
gone into the issue. It simply upheld the order passed by the single bench, passed by the High Court.
Lordship. And
So,
that is challenged
that's
before.
all right, but having gone through the subsection 4 to section 4.
I've seen, Lordship.
Yes.
That I've seen, Lordship.
Let us do one thing.
Lordship.
We'll fix it in the next week. In the meantime, you go through the provision and find out some decision of the High Court or Supreme Court.
Lordship.
In this regard.
Lordship.
That would be better. Mr. Day, learned counsel for the appellant, and Ms. Sharma for the respondent. Heard in part, list the matter on. No.
Twenty.
29th of August. Oh, no, sorry, July.
Yes.
For further hearing.
Obliged, Lordship.
Obliged.
Item 15.
Yeah, please, Your Lordship, kindly the matter may be passed over for the time being, as the engaged counsel is on leg.
Whether all the parties are present? So respondent number 1 to 4. Mr. Gogo, you were for?
I am for 567.
567.
Lordship.
Who is for 1 to 4?
MJ Kadir.
Have you seen them?
No, Lordship.
No. Yeah, we'll take it up at 2 o'clock then.
Bless.
Thanks.
Item 16.
Your Lordship, 16 also same. Passed
Same.
for the time being. Time being, Lordship.
Okay.
I'm responding in this case, my lord.
You are respondent.
I'm responding, my lord.
Item number 19.
19, my lord. Appellant was there.
Appellant is absent.
He was there sitting with me.
Who?
The appellant was there sitting with me, but I don't know where it was now.
You have seen?
He has been there, but now he's not. Nothing be done now.
Mr. Kayo?
Yes. I don't know his name, but he was sitting with me.
Okay, then at 2 o'clock. 2 o'clock.
At 2.
Next.
20.
Lordship, may take it up at 2, Lordship.
Why?
Oh, oh, sorry, no, no. Senior counsel is on legs in court number 10.
Okay.
21 similar prayer, Lordship.
Pardon?
21 similar prayer, Lordship, item number 21.
Similar pair. Okay.
Lordship,
In item
item 20 number 21 is concerned, your Lordship. I am the petitioner here.
see, praise for listening after.
At 2 o'clock, sir, it's in.
It will be taken up at 2.
Yes,
All
yes.
right. Alias, I am petitioner, your Lordship, I may be hard, they will argue at them. Please, sometime.
Yes.
Lordship. Because, sorry, I need to.
Huh?
Lordship, let my senior come at 2 o'clock.
Pardon?
Let my senior come at 2 o'clock, Lordship, it may be heard then.
Okay, in the meantime, let him start.
Yes. Start going with this.
21. May it please your Lordship. Lordship, the present petitioner was the plaintiff landlord, your Lordship, before the trial court. Suit was filed, your Lordship, on the ground under the Urbanized and Control Act, defaulter as well as bona fide requirement, your Lordship. So the trial court, your Lordship, decreed the suit on the ground bona fide requirement is there that son of the plaintiff, he's a MBA and he's sitting idle. He's running a only confectionery, bakery and grocery shop just in the vicinity of the suit premises, your Lordship, which is only 275 square feet, so which is not sufficient at all. It was the finding of the trial court, your Lordship. So the court was convinced that there is bona fide requirement for the son of the plaintiff with an MBA, your Lordship. And his daughter, she is also, your Lordship, BA Tech, your Lordship, and this premises is necessary for that purpose also. So the other side, your Lordship, the present respondent, they being aggrieved, preferred an appeal before the Civil Judge Senior Judge number 2, your Lordship, challenging the decree, your Lordship, that there is no bona fide requirement and that they are not defaulter in area of that. Anyway, your Lordship, as against the point of defaulter which was decided against the plaintiff petitioner, your Lordship, by the trial court. So we preferred a cross-examination, cross-objection, your Lordship, under order 41 Rule 22. That the bona fide requirement, your Lordship, so far it is concerned, it has been decreed on that, but their defaulter also side by side. So that point should be decided against the defendant and in favor of the plaintiff. So the first appellate court, your Lordship, rejected our plea of this defaulter, your Lordship, and a cross objection which we filed, your Lordship, that has been rejected. By your Lordship, the bona fide requirement, that ground on which the suit was decreed, your Lordship, that point has also been reversed, your Lordship. So ultimately, your Lordship, result is that the suit has been dismissed. On both the count, that is, he is not defaulter and there is no bona fide requirement. That is the case, your Lordship. Now, so far the bona fide point requirement is concerned, your Lordship, there is strong evidence, your Lordship, There is strong evidence, your lordship. I am taking your lordship. First, your lordship to the plaintiff. Your lordship will find from the plaintiff at page 19, your lordship. Para 5, your lordship will find at page 24.
Para 5, okay.
Para 5 of the plain at page 24, your lordship.
Yes.
Para 5, that the plaintiff states that the room is bona fide, honestly and sincerely required by the plaintiff for his personal use and occupation as well as for his family members. The plaintiff has got a son and a daughter, and both of them have completed their higher studies. The son has completed his MBA in retail management from Sikkim Manipal University, and his daughter has completed her graduation in BSc IT. The plaintiff's son Sri Mithun Boisha is running a bakery confectionery along with grocery item as business along with the fast food counter namely AB Enterprise from the adjacent room attached to the suit premises, which is flourishing with the passage of time. The aforesaid space for running his shop in the name of AB Enterprise is only 275 square feet and is not at all sufficient to run the present business. Further, the plaintiff and his family members have intended to expand the existing business by opening departmental store along with the present business carried in the name of AB Enterprise. For running the present business and the proposed departmental store, it is necessary to combine both the rooms, that is the present room measuring 275 square feet and the suit premises measuring 500 square feet, which in total will come about 775 square feet. The only requirement will be for combining both the rooms is to demolish the middle and the intervening walls. Moreover, the suit premises is also required to augment the income of the plaintiff and his family members and expansion of the present business from the adjacent room. The suit room is facing the main road at Adgaon and is located at the most commercial and viable locality of the city and is ideal for plaintiff's son and the daughter to start their business and move ahead with their lives. So this is the foundation, your lordship, pleadings. On this pleading, your lordship, same is the reproduction of the evidence is nothing but a reproduction of this statement made in paragraph 5. So suit premises is 275 square feet. The adjacent, the premises, your lordship, that is suit premises into 500 square feet. And the room, your lordship, in which now the plaintiff, his son and daughter is running business, that is of grocery, bakery, and fast food, your lordship, it is only 275 square feet. So that is room, your lordship, much more smaller than the suit premises, and both the rooms are adjacent to each other. If both the rooms are combined, your lordship, it will come to 775 square feet. And it will be a very good space, your lordship, to open a departmental store, plus the existing business, you know, to run that from that place, as well as some other business can be also run, your lordship, to augment the income of the plaintiff, his sons and the family members. So under the law, your lordship, this sort of bona fide requirements, it is recognized. There are Supreme Court decisions, our High Court decisions are there, your lordship. That this sort of requirement, your lordship, that cannot be refused, cannot be declined, your lord, by the court. But here in this case, your lordship, the court has considered a fact that there was a title suit, Your Lordship, in the year 2008, that is title suit number 273/2008, Your Lordship, in between the present plaintiff and the defendant, Your Lordship. That was a suit of the year 2008, being 273 title suit for ejectment, declaration, and area rents. So, after discussion and negotiation, Your Lordship, that suit was compromised. That was also suit, Your Lordship, for defaulter, bona fide requirement, area rents, Your Lordship. At that time, my daughters and the son, Your Lordship, they were college students in the year 2008. Now, the present suit has been filed, Your Lordship, in the year 2016. So, 2016 and Your Lordship, 2008, there is a difference of 8 years, Your Lordship. Court has taken considered the fact of that earlier title suit, Your Lordship, that is 273 of 2008, that as there was a claim of the plaintiff bona fide requirement as well as area rent as well as the defaulter, Your Lordship, in the year 2008. Now, the same person, he has filed the present suit for the same relief. So, there is no bona fide requirement. So far, defaulter point is concerned, Your Lordship, that has also been decided, Your Lordship, in a perverse manner. Now, that finding, Your Lordship, is not tenable, sustainable in law. So far, the bona fide requirement is concerned, it cannot be concerned what happened in the earlier suit in the year 2008. That cannot be a subject matter, Your Lordship, to consider and a conclusion that there is no bona fide requirement. That is the great mistake, Your Lordship, to my opinion, the learned First Appellate Court has committed. Now, Your Lordship, I am coming to the decision of that is a judgment rendered by the First Appellate Court, Trial Court, Your Lordship. It is at page 55, Your Lordship.
Yes.
So, Your Lordship will come to the page 61, Your Lordship. The issues, Your Lordship, which are framed by the trial court, Your Lordship.
Yes.
Issue number 4, whether the suit premises is required bona fide for the purpose of the plaintiff, Your Lordship. And 3 is, Your Lordship, whether the defendant is defaulter in payment of rent in respect of the suit premises. So, Your Lordship will find here in the pleadings that we have pleaded that the defendant has defaulted in payment of rent since the month of December 2015. December 2015 is the month, Your Lordship, since when they are actually defaulted in payment of the monthly rent. Now, Your Lordship will come to the issue number 5, Your Lordship, how it has been decided by the trial court. At page 69, Your Lordship.
Yes.
Issue number 5, whether the plaintiff is entitled to recover or not, that, Your Lordship, sorry, Your Lordship. Issue number 4, Your Lordship, at page 66. Page 66, Your Lordship. Para 10. Para 10, page 66, Your Lordship. Issue number 4. Section 5(1) of the Assam Urbanized Land Control Act 1970 states that no order or decree for the recovery of possession of any house shall be made or executed by any court so long as the tenant pays the rent to the full extent allowable under the said act and performs all the conditions of tenancy. The proviso C provides that a suit for proceeding for the eviction of a tenant will lie in case C where the house is bona fide required by the landlord, either for the purposes of repairs or rebuilding or for his own occupation and for the occupation of any person for whose benefit the house is held, or where the landlord can show any other cause which may be deemed satisfactory by the court. 11. The plaintiff has submitted that the suit premises is bona fide, honestly and sincerely required by the plaintiff for his personal use and occupation as well as for his family members. The plaintiff's son is running a bakery and confectionery business along with a fast food counter, namely Abbey Enterprise, from the adjacent room attached to the suit premises, which is flourishing with the passage of time, and the aforesaid space for the running the said shop in the name of Abbey Enterprise is only 275 square feet and is not at all sufficient to run the present business, and the family members of the plaintiff have intended to expand the existing business by opening a departmental store. The plaintiff has stated that his son has been sitting idle for 3 years since 2013 till 2016 as he could not extend the shop due to running tenancy agreement till 3/1/2016. 3/1/2016, Your Lordship, that is the time, Your Lordship, by which the agreement, Your Lordship, was entered into. And in the said agreement, it was entered into on 4/1/2011. The present tenancy, Your Lordship, by virtue of an agreement, Your Lordship, that was entered into on 4/1/2011 for 5 years, Your Lordship. For 5 years, 4/1/2011, and if 5 years is added, Your Lordship, the time expires on 3/1/2016. That is the expiry of the tenancy, Your Lordship, unless it is renewed. If it is renewed, Your Lordship, that is different. Your
Time expired on 16.
expires on 3/1/2016. That is 5 years from 4/1/2011.
Okay.
And due to running tenancy agreement till 2016. Moreover, the plaintiffs have submitted that the suit premises is needed to augment the income of the plaintiff's family members and expansion of the present business from the adjacent room. Adjacent room means, Your Lordship, the room from which business is being run now, Your Lordship. 12. The defendant submitted that as per the agreement executed between the parties, it was agreed upon that the said agreement was for a period of 5 years with an understanding between the parties that the suit premises will be vacated by the defendants when it would be required by the plaintiff for his own personal use and occupation as well as for the members of his family after the expiry of the terms of the agreement, and that the aforesaid agreement expires on 3/1/2016 are all false and frivolous claims made by the plaintiff. Further, the defendant submitted that there is no such requirement of the suit premises by the plaintiff or his family members as alleged by the plaintiff, and the said ground has been taken by the plaintiff only to pressurize the defendant to bow to his demand for increase of the rent from rupees 2,500 to 7,000, which was not accepted to the defendants. In this regard, I would like to place reliance in one of the decisions of the Honorable Supreme Court in case of so-and-so, wherein the Honorable Apex Court has observed, it is always the prerogative of the landlord to decide for what purpose he requires the premises in question. In this case, for his bona fide use and expanding his business, it cannot be a ground to say that the landlord is already having his business in other cities and therefore such need is not genuine need. It is not tenant who can dictate terms to landlord, advise him what he should do and what he should not. 13. Para 13. Further, if I go to the cross-examination of DW1, he has admitted the fact that the room used by the plaintiff and his son is smaller than the shop room of DW1, and their room is DW1 means your lordship is defendant number 1, and their room is adjacent to the shop room of DW1. 14. Thus, after analyzing the evidence laid down by the witnesses in the light of the above referred observation of the Honorable Apex Court, I am of the view that the plaintiff is having a bona fide requirement of the suit premises. Accordingly, this issue is decided in affirmative and in favor of the plaintiff. So, bona fide requirement so far the finding is concerned, your lordship. Based on evidence, your lordship, he has considered all pros and cons, your lordship. No evidence has been left out, your lordship. And after having considered and having relied upon the decision of the Apex Court, and there are other reasons also we cited, your lordship. Those have not been mentioned here, but one mentioned, your lordship. From that, your lordship, it is the finding of the Honorable Court that it is the prerogative of the landlord to get his rented premises back, your lordship, provided he can show that the premises is bona fide required either for his own purpose or for the purpose of any of the family members or the entire family, your lordship. In that case, it is sincerely all, your lordship, that there is a genuine need of the plaintiff for the bona fide requirement. And on that basis, your lordship, decree has been passed. Now, as I have already submitted, your lordship, the trial court, your lordship, the first appellate court, your lordship, deviated from the finding of this trial court, your lordship, and has come to finding that there is no bona fide requirement because he earlier filed a suit, and in that suit there was a compromise, that means, and the rent has been enhanced, and he has taken salary of such and such amount. So that's why there is no bona fide requirement, which happened, your lordship, in the year 2008, 273 of 2008. So after 2008, your lordship, in the meantime, up to 2016, your lordship, he became the MBA, your lordship, his son. And the daughter also, your lordship, she has graduate, she has passed graduation, your lordship, and is sitting idle. So son, daughter, as well as the plaintiff for himself and the family members, whatever is required, your lordship, it cannot be called that it is fancy, your lordship, not genuine, your lordship, that it is actually unnecessary claim that cannot be held, your lordship. At least there are other instances also in this regard, which says that the narrow interpretation should not be given. A liberal interpretation should be given so far the personal use and occupancy is concerned, and liberal interpretation should be given so that it can include even the married daughters also, your lordship. Even the persons who are dependent on the, say, your lordship, plaintiff, your lordship, landlord. So those persons can also come within the definition of this family, your lordship. And that family requirement is also, it is recognized under the Urbanist and Control Act, your lordship. So for the state of Assam is concerned and other state also, your lordship, provisions are almost similar, your lordship. So it is the decision of the Supreme Court as well as our court also, your lordship, number of umpteen decisions. Wherefrom it transpires, your lordship, that bona fide requirement is the requirement of the landlord, his family members and daughter sons are included. That we have fulfilled, your lordship. So the finding given by the first appellate court, I'll be coming to that, your lordship. Later on, your lordship. Now your lordship will find issue number 3. Issue number lordship.
Yes, page 64.
Lordship, at 2, lordship, it is going to be.
Okay. But it may not be immediately at 2 o'clock because yesterday we have fixed another matter at 2 o'clock.
At 2 o'clock.
Yes.
So I'll be waiting, your lordship.
You come after sometime
Lordship,
at 2:30
lordship,
or around 3.
lordship.
May please, your lordship. Lordship, in item number 9, lordship, there is an interim order, lordship. That may be continued.
Item number 9.
Item number 9, lordship.
Yes.
Obliged, lordship.
To be spoken to item number 28.
Mr. Professor,
My lord.
Rule 27 of the Central Reserve Police Force Rule 1955
My lord.
provides for the procedure for the award of punishment. Then while awarding punishment, whether the disciplinary authority had followed the procedure prescribed under Rule 27 C4 of the Act. The accused shall then be examined and his statement recorded by the officer conducting the inquiry. From the file you have produced before the court,
My lord.
can you show the court that his statement is recorded, was recorded? Yes.
My lord. If it is there, my lord, if it is there, I will flag mark, my lord.
Yes. And the file is written in Hindi.
Yes, that is. My lord, if required, my lord, I can.
Who will translate it?
My lord.
Who will translate?
In some cases, my lord, we make translate through the, my lord, High Court's translator.
Translation wing.
My lord, yes.
Okay, you go through it. You let this court know after some time.
My lord.
After some time. In the meantime, cooperate partners method.
My lord, there is only that much.
Yes. No other point.
I can leave the court. He will be there.
Huh?
Already.
Item fixed at 2 p.m. Item number 31. Lordship, my humble apologies regarding this particular matter. The main counsel who is arguing this case, Lordship, he's on legs in court number 14. There's a Lordship, my humble apologies, Lordship. Lordship, regarding this matter, main counsel who is handling this case on behalf of the finance department, he's on legs in court number 14. There's another 2 o'clock matter fixed over there. Might take some time, Lordship. So I am praying that let this matter be taken up after some time.
Or something. We have several other matters.
Lordship. That is the difficulty. Lordship.
Can it be on? Okay. Monday, next Monday?
Monday. Or my lord, can it be on Friday or Thursday coming week, my lord?
Thursday, Friday, we have already fixed a lot of matters. So therefore, let it be on Monday.
My urgency is, my lord, I am without salary from last many years. My lordship. As
That's
per
all right. Your part is already
over, my
compromised.
lord.
Only in the finance
Yes.
department. So,
Yes, my lord, as per convenience of my lordships, my lord.
okay. As agreed by learned advocates of both the parties, raises at least this matter on Monday. Monday at 2 o'clock. At 2 o'clock.
Much obliged.
Obliged.
Here, item number 2.
Wait, please, my lord.
In this. Yes, you are for the petition?
Yes, my lord. I am for the petition, my lord.
Heard, Mr.
NBP Singha, my lord.
Your name is not there?
My lord, I have filed, my lord, the Wakalanama recently, my lord. But
When?
On the last occasion, my lord, the last, if my lord sees the last order, my name is, my lord, mentioned in the order, my lord. But my name is yet to be reflected. I have filed Wakalanama 16th May.
Heard, Mr. and NPP Sinha, learned counsel for the petitioner. None appears for the respondent not called. It appears from the order dated 3/6/2025 that the respondents also remain unrepresented on that day. Accordingly, it is provided that SSL is this matter. Fixed that it is 2016 matter or 28 July. And in the event of subsequent non-representation of the respondent, appropriate order shall follow.
All right.
Number 21.
Yes, we are on issue number 3.
Issue number 3, Your Lordship.
Yes.
It is at page
64. Paragraph number 9.
whether the defendant is defaulter in payment of rent in respect of the suit premises. Your Lordship will find our particular case is, Your Honor, that the plaintiff received rent up to the month of November 2015. Since December 15 till date, Your Lordship, there is no tender of rent, Your Lordship, by the plaintiff, Your Lordship. Anyway, Your Lordship, according to the tenant respondent, that is defendant, Your Lordship, he paid rent for the month of December 2015 by check. And that check was not accepted by the landlord present petitioner, Your Lordship. It was not accepted by the landlord petitioner. Very good. If that be the case, that a check has not been accepted, that means you have come back with the check. During the course of evidence, you ought to have produced that check, that this is the check, so and so number, and this was tendered to the landlord, and he refused to accept. Because under the Assam Rent Control Act, there are a number of decisions that you must prove the tender. Tender must be proved. If you can't prove the tender, then you can't deposit rent in court. First precondition is, Your Lordship, for depositing rent, the tendering of the lawful rent, Your Lordship.
No, you have already submitted that he paid the amount by check. Then
it was, according to defendant, it was not accepted by the landlord. If it was not accepted, that means the check is with the defendant. Lordship, am I clear? Lordship, he paid the rent for the month of December in the January 2016, Your Lordship, by check. And that check was not accepted by the landlord plaintiff, Your Lordship. If not accepted, then non-acceptance means, Your Lordship, that this check has been returned to you. That I am not going to accept it. So it is with you. Then is it not your duty to show or prove that this is the check which was tendered to the landlord plaintiff and he refused it to accept? And thereafter I started depositing rent in court, Your Lordship. And that is the precondition. Tender is a precondition, Your Lordship. Without tendering or lawful payment, Your Lordship, no rent can be deposited in court, Your Lordship. That is the Supreme Court also, Your Lordship, on the Assam Rent Control Act.
no, as per your version, your submission, he tendered the rent for the month of December 2015 by way of check, and you have not accepted it. So you have admitted it. So what proof is required?
No.
Regarding tendering.
It is his case, Your Lordship, that I did not accept. Landlord has not accepted it.
That's all right.
Gotcha.
But
Then
he tendered the
tendered.
yes.
If that tender is accepted, then check is with you, that this is the check I tendered to the plaintiff, Your Lordship. Because when the check has not been accepted, definitely it has been kept by the defendant, Your Lordship. It is with the defendant, tenant. So this was the check. I have not accepted, or to that effect, I have no answer, Your Lordship. It is your duty that it was tendered to you, and I did not accept. So acceptance has been, according to him, Your Lordship, I refused. So if I refuse, you will have to prove that you tendered the check. You tendered the check. Where is that check, Your Lordship? That has not been brought to record, Your Lordship.
That was not exhibited.
Lordship?
That check was not exhibited during trial.
The check was not exhibited. Had it been exhibited, Your Lordship, it would have proved that this is the check and you did not accept, and number, date, everything will be apparent, Your Lordship, from the check itself. So whatever he said, Your Lordship, that is not correct. If it is not correct, Your Lordship, then Your Lordship is a defaulter. Defaulter for 1 day or defaulter for a month or years, your lordship, consequence, civil consequence is
Will be safe.
same, your lordship, that he is once a defaulter, always a defaulter. Now, he had not proved the check exhibited also, your lordship. And that's why, your lordship, it is our case that he failed to produce the check in court not exhibited. That's why it ought to have been held by the trial court as well as the first appellate court, that is a defaulter. And that has not been held by the trial court as well as and that is the perverse finding. That finding is not correct, your lordship. That finding is to be corrected by this honorable court, because apparently, your lordship, they have failed to prove that there was any tender or payment of the rent.
So whether there was any cross-examination on that?
Yes,
point?
your lordship. Detailed cross-examination is there, your lordship. I will be coming to that. Detailed cross-examination is there that you did not tender any rent for the month of December 2015 by check on 7/1/2016. Have you proved it? Have you exhibited it? Have you produced it before the court? And the check is with you. You admitted that check is with me, but have you produced it before the court? Exhibited it? Negative result here. Negative answer. That's why, your lordship, that he is defaulter. So for bona fide requirement, your lordship, I have gone to the pleadings only, your lordship. The evidence I will be, I have read out, your lordship, evidence also. I will be coming to that also, your lordship. There are a number of decisions on that point. Those will be cited, your lordship, will be placed before your lordship. Now, your lordship will issue number 3. How it has actually dealt with the trial court, your lordship. And that has been echoed by the appellate court also. The lordship at page 64.
Yes.
The plaintiff has alleged that the defendant has made a default in payment of rent from the month of December 2015 to September 2016 at the rate of rupees 2,500 per month. The defendant has submitted that when the plaintiff did not come to collect the rent for the month of December 2015, DW1 offered the rent for the month of December 2015 to the plaintiff on 7/1/2005, check number 00279 dated 7/1/16 drawn on Bank of Baroda. However, the plaintiff refused to accept the rent, and so the defendant left with no other alternative, deposited the rent in court after observing all the necessary formalities. Upon perusal of the case record, it appears that the defendant has exhibited the challenge showing deposit of rents as exhibit G1 to G19. However, the defendant has not exhibited the check number so and so. Lordship got it. The defendant has not exhibited the check number so and so, which was tendered by him to the plaintiff. During cross-examination, PW1, who is plaintiff number 1, has admitted the fact that after the expiry of the agreement for tenancy on 3/1/2016, he did not collect the rent and refused to accept the same as period of tenancy expired, and further deposed that he does not know, and it was not within the knowledge that the defendant have been depositing rent for subsequent months in court. So and so offense has been made, your lordship. Now I'm coming in a case, therefore, where the defendant takes the plea that he is not a defaulter because he has been depositing the rent in court under section 5(4) of the Act, in that event, burden heavily falls on the defendant to plead and establish all the aforesaid conditions precedent. If any of those conditions precedent is not pleaded and established, in that event, deposit of rent will not be a valid deposit, and the tenant will not get the benefit of section 5(4) of the Act, so as to avoid the rigor of default under section 5(4) of the Act. In the instant case, the plaintiff himself has admitted in his cross-examination that he refused to accept the rent on 3/1/2016. On 3/1/2000, thus the defendant has been able to prove the offer of rent to the landlord before the deposit as well as the refusal by the landlord to accept the rent. Since the fact is admitted by the plaintiff, which shows that he was offering the rent of December 2015 by the defendant and that he refused to accept the same, so the deposit made by the defendant is held to be a valid deposit, and as such, he will get the benefit of section 5(4) of the Act. Now, the mistake committed by the trial court, same mistake by the appellate court, Your Lordship. Deposit of rent, Your Lordship, we are not on that, Your Lordship. We are on whether you tendered the rent for the month of December 2015 on 7/1/2016. Whether you tendered. If you tendered by check, what prevented you from exhibiting, producing, and marking the said document, Your Lordship, in the records of the case? You did not do that. My refusal is, Your Lordship, that on 3/1/16 it expired. So therefore I did not, Your Lordship, declare to accept any tender of rent, Your Lordship, after that. So you have deposited, but so far your tendering is concerned, particular tendering is concerned, Your Lordship, for the month of December, that you have not proved. You have failed to prove. Had it been the case, Your Lordship, that this is the check by which actually I tendered and he refused to accept. My refusal is general, Your Lordship. My refusal is general that as I need the suit premises, Your Lordship, for myself as well as my daughter and son family members to do business from that premises along with the premises wherefrom we are running business now. Being a small room, Your Lordship, and if it is added to the suit premises, it will be a bigger one, so it will be convenient for us to do the business, Your Lordship, the way we like. That is the case, Your Lordship. Now, question is, Your Lordship, what prevented that you tendered the rent for the month of December, and this is the check. You have not proved that. That means you did not tender. Not tendering is a default on the part of the tenant defendant, Your Lordship, that you won't get benefit under section 5(4) of the Urbanized Land Control Act. So tender has not been proved. If tender has not been proved, our decision of Zen Sharma is there, Your Lordship, that it must be proved. Tender must be proved. Refusal is another part, Your Lordship. That refusal is general. Now, in the light of the above discussion, it can be held that the defendant is not a defaulter in payment of rent, and as such, this issue is decided in negative and in favor of the defendant. So this is the finding, and defaulter, that point, Your Lordship, has been decided against the plaintiff.
But though the defendant has not exhibited the check, he has mentioned the number of the check.
Lordship, he has given the number of the check, everything, Your Lordship, but it was with him. But it was with him, Your Lordship.
Okay.
So that means, Your Lordship, the court, according to our contention, Your Lordship, the court ought to have held that he is a defaulter for the month of December
So
2000.
where is that decision?
Lordship,
Where is that decision?
petition.
Decision.
Sorry, Your Lordship. I will come. Because there's so much decision today. Decision so much. The decision 1997. अच्छा, विकास ना? Okay. 1997 2 GLT 590 paragraph 9. Your Lordship. Para 9, your lordship got it. Paragraph 9.
Yes.
Got it. Regarding the deposit of Ryan in court under section 5(4) of the Act, there must be evidence that there was refusal by the landlord. In a series of cases that this court has held, that section 5(4) of the Act is a mandatory provision, and the tenant seeking protection under the provisions must tender or offer due rent within a fortnight of its falling due. The tender must be made, which is the precondition to deposit the rent in court. The question of depositing rent in court comes when the landlord refuses to accept. So, your lordship, so far the month of December 2015 is concerned, it is my due, your lordship. I am entitled to get it. So there is no question of refusal. The courts wrongly interpreted, your lordship, that I refuse to accept. It is not that, your lordship. I refuse to accept, your lordship, afterwards. That there will be no acceptance. But so far, December 2015 is concerned because it is valid, the tenancy is valid only up to 3/1/2016. Before that, whatever months come, your lordship, for that I am entitled to get the rent, your lordship. Up to December, it is all right, your lordship, because I am entitled to get, there is no question of refusal. If there is refusal, your lordship, it must be proved by independent witness that I accompanied so and he tendered the rent and it was refused by the landlord, your lordship. Where is the evidence to that effect, your lordship? So there must be precondition is tendering of the rent and refusal. Both the things must be proved, your lordship, one after another. First is tendering of the rent, lawful rent. Second is, your lordship, it was refused. Mere saying will not do, your lordship. Tender must be made, which is the precondition to the deposit of rent in court. And, your lordship, after the expiry of the tenancy, your lordship, by efflux of time. By efflux of time, if the tenancy is determined. So deposit thereafter, your lordship, it is meaningless, your lordship, unless there is renewal. So it must be renewed. There must be acceptance of rent. If there is acceptance of rent, your lordship, it is holding over. Or a tenant at will. If it is not accepted with the dissent of the landowner, your lordship, then if you continue possession, that is illegal, that is you are a tenant at sufferance. A tenant at sufferance, your lordship, has been defined by our High Court following the Supreme Court decision. His position is akin to illegal possession and trespasser. But he will not be evicted so far there is a decree or an order passed by the competent court to that effect. There must be a court's decree, though he is a trespasser or unauthorized occupier, a tenant at sufferance. A tenant at sufferance, your lordship, he has no right to continue, your lordship. His possession is illegal and that of a trespasser akin to. The tender must be made, which is the precondition to the deposit of rent in court. The question of depositing rent in the court comes when the landlord refuses to accept the rent. This question now has been cleansed by a recent decision of the Apex Court 1995. It was in a whole decision at us. It's no whole. এই এক পেজৰ একদম ন একদম সৰু ডিসিশন এটা চাবাচোন Cleansed by a recent decision of the Apex Court in 1995. 1995 Supplementary 3 SCC 44, Rameshwar Lal Chaudhary wherein the apex court, wherein section 5(4) of the act was considered by the court and the apex court has pointed out as follows. And this is the order, your lordship, and this is the judgment also, your lordship. This is the judgment. In this case, in which the appellant tenant did not tender the rent to the landlord, without resorting to such tender, he has deposited the rent into the court. That is not in compliance with section 5(4) the Assam Rent Control Act 1972. The High Court is correct in its conclusion. Civil appeal is dismissed, no pause. Alina, itu? একদম সৰু decision আছে একটা হেৰি আছে। Court আছে, sir. Anyway, your lordship, the decision actually, this is the paragraph of that decision and it's just quoted here.
Okay.
So I'll place it, your honor, when available. Okay, sir. Into session. So that's why, your lordship, that he is a defaulter, your lordship, it is cleansed by himself, your lordship. That he is a defaulter. Now, your lordship, these are the 2 points. Now, your lordship will come to the agreement, your lordship. What is the agreement, your lordship? Now they are relying upon the agreement that this is an agreement of tenancy or lease, your lordship, for infinite time.
For
Infinite time, your lordship. No definite certainty, your lordship. All times to come. So under a tenancy agreement, under the Rent Control Act, it cannot be for indefinite time because it is a month-to-month tenancy. If there is any breach of contract, breach of tenancy, bona fide requirement, or any other 7 grounds as contemplated under the Urbanist Rent Control Act, your lordship. So he is liable to be deferred. That means evicted, your lordship. That means a tenant is liable to be evicted on as many as 8 grounds as contemplated. Rent Control Act. Contemplated under provision to section 5 of the Rent Control Act, your lordship. And what are those grounds, your lordship? I'm just reading, your lordship. So if an agreement is made, your lordship, supposing agreement is there, an agreement against the provision of law, it is void. An agreement cannot prevail upon the provisions of law. They can't go against the law, your lordship. That agreement is illegal.
That's it, agreement.
Yes. Now, your lordship will find the section 5 of the Admissibility Rent Control Act, bar against passing any execution, an execution of decree, an order of ejection. No order or decree for the recovery of possession of any house shall be made, executed by any court so long as the tenant makes payment to the full extent allowable under this act and performs the conditions of the tenancy, provided that nothing in the subsection shall apply to a suit or a proceeding for eviction of the tenant from the house where the tenant has done something, your lordship, contrary to the provisions of subsection M, O, or clause P of the section 108. It has been borrowed from the Statutory Property Act. That is A. B, where the tenant has been guilty of conduct which is a nuisance. C, where the house is bona fide required by the landlord either for the purpose of repairs, rebuilding, or for his own occupation, or for the occupation of any person for whose benefit the house is held, or where the landlord can show any other cause which may be deemed satisfactory by the court, or where the tenant sublets the house or any part thereof otherwise transfers his interest in the house or any part thereof without permission in writing from the landlord, or where the tenant has not paid rent lawfully due from him in respect of the house within a fortnight of its falling due, where the tenant has built, acquired, or has been allotted a suitable residence. These are the grounds, your lordship, on which a tenant can be evicted by the landlord, your lordship. So out of those, your lordship will find that is 5C, your lordship, bona fide requirement. And that is E, your lordship, that is the payment of monthly rent, your lordship, on the ground of that is defaulter. Now, these are the two main grounds generally taken in the eviction suit under the rent control act. So that being the position, your lordship, supposing an agreement has been made for indefinite period, giving a good.
Let us see the agreement.
Yes, sir.
Is it part of the record?
Yes, it is with the main petition itself. Your lordship.
Okay. Page number?
It is at page, your lordship, 45.
Page 45. Yes.
Lordship, it may be read from the page 49, your lordship come. Page 49, the main content, terms and conditions, your lordship. That pursuant to the aforesaid understanding and agreement now, this did witness it as thereunder. Your lordship has got it. Got it. That the second party tenant shall pay in the manner aforesaid an interest-free salami premium amounting to rupees 1.5 lakhs, 1,50,000 only in 3 installment as under. This is A, B, and C, your lordship. That in that mode, your lordship, the tenant will pay a salami of rupees 1,50,000. Now they have taken a plea, your lordship, that salami is illegal. It cannot be released from the tenant. Now there is conflict. There are some state rent act, your lordship, not in Assam, your lordship, in the other states, your lordship, within India, that taking of salami is illegal. In the act itself, there is a bar. There is if somebody realize any salami or other premium, your lordship, then it is illegal, because in the act itself there is a bar. Now they have taken a plea, your lordship, that I have charged the salami of rupees 1.5 lakhs, your lordship. That cannot be illegal, because it is a matter of, again, a contract between the tenant and the plaintiff, your lordship, landowner. And under our act, your lordship, under the Assam Rent Control Act 1972, there is no such bar that taking or accepting salami is a bar, your lordship, and it is illegal and it cannot be so realized. So that is not applicable so far Assam State Rent Control Act is concerned. 3, that the landlord shall be liable to pay the landlord to your lordship, that the rate of monthly rent during the currency of the agreement shall be 2,500 per month, payable within the first week of every subsequent English calendar month, and upon receipt of rent, the landlord shall grant a receipt. That the 3, that the landlord shall be liable to pay the revenue, local rates, municipal taxes, rates for the property, and the tenant shall not be liable to make payment of any of the aforesaid items. 4, that it has been mutually agreed between the parties thereof that the tenancy agreement shall be for a period of 5 years, and it shall be renewed automatically without any fresh agreement, and the rent shall be enhanced by 15% automatically after the lapse of the period of 5 years over the existing rate of rent, and the tenant shall be liable to pay such increased revised rent as agreed by the tenant without any notice by the landlord. This increase in rent shall be automatic and shall be over existing rate at every time of 5 years. That means as per this clause, your lordship, that is the period of tenancy is uncertain. There is no certainty. And this clause, your lordship, they are relying upon heavily, your lordship. That as per this, no renewal is necessary. It is axiomatic that it will happen after every 5 years. Only thing, the rent will be enhanced by 15%. Now this clause, your lordship, ab initio void because it has been made against the provisions of the act. Because in the act, your lordship, there is no such clause, renewal or
You
non,
are a signatory in this agreement.
lordship.
You have agreed to the same. Now, can you argue against this clause?
Lordship.
Because you have signed over the same consciously.
Now, under section 29 of the Contract Act, your lordship, Contract Act, your lordship will find that this type of agreement is void.
No, the question is
Because
you signed
supposing,
the same act.
supposing landlord
Can you-
requires bona fide.
Can you approve it and reprove it at the same time?
No. This clause, your lordship, without this clause also, your lordship, the agreement is valid. It is complete, your lordship. Now they have taken shelter of this in such a manner that they are saved. If it is supposing, your lordship, they have destroyed the building, your lordship, so it cannot be, they cannot be evicted. If bona fide requirement is there, then also it cannot be, they cannot be evicted. So, and any other grounds as contemplated under proviso to section 5, your lordship, they cannot be evicted. They have inserted a clause, your lordship, in the rent code to let by this, your lordship, that it is for infinity period, only the rent will be enhanced after every 5 years, your lordship, at the rate of $50. So this sort of clause, your lordship, cannot be read along with the other grounds, your lordship, as contemplated in section 5. Now, your lordship will find this 29 of the section 29 of the Contract Act. So this agreement, this clause is has no legal sanction. It is against law. Section 29, your lordship. Lordship got it.
Yes.
Agreements void for uncertainty. Agreements, the meaning of which is not certain or capable of being made certain, are void. Supposing, your lordship, tenant dies, landlord dies, your lordship. What will happen to your lordship? Will they be bound, your lordship, that it will continue by this agreement, this clause, your lordship? Supposing landlord dies and his heirs come in, will they be bound by this, your lordship? So it is forever without certainty, your lordship. Neither the tenant nor the plaintiff, your lordship, there is no certainty. It is a month-to-month tenancy under the Urbanist Rent Control Act, your lordship. The very purpose of the act is month-to-month. Monthly tenant, monthly rent, your lordship, everything monthly. Not yearly or lordship, biennially or lordship 6 monthly. Half yearly, your lordship. There is no such provision. It is month-to-month. You will have to pay month-to-month. You may pay at a time the 12 months rent, but that does not mean that it has become year to year, your lordship. It is monthly. So that's why, your lordship, section 29 says that it is uncertain. There is no certainty. And after the death of, say, plaintiff or the tenant, your lordship, that somebody will come and they will say, no, the agreement is there, I am the heir of the tenant, so I will continue with the same conditions, same terms, your lordship. That's why the contract that has taken care of this provisional also, your lordship. There cannot be a tenancy, your lordship. There cannot be a contract, your lordship, with a term which will be uncertain, your lordship. It will be for all times to come, your lordship. There cannot be such.
Okay.
And it is against the law, your lordship. That is the thing, your lordship. So bona fide requirement is my personal right. If it is required, your lordship, this clause, your lordship, can't prevent me. And this is a clause, your lordship, debarring me from exercising my rights.
How that the issue of bona fide requirement was dealt with by the appellate court? First appellate court?
The
Yes,
same
appellate
decision, your lordship, same decision 273 of 2008, your lordship, that has been. So I read it, your lordship. There cannot be a clause in an agreement which will negate the entire act. Your Lordship, 55, it starts.
No, the appellate court.
Yes, Your Lordship. It is 120, Your Lordship.
Which is the relevant paragraph?
I'm coming, Your Lordship. Your Lordship, this is at page 114, Your Lordship, 44. Issue number 4.
Yes.
The requirement of the suit premises shown by the plaintiff for expanding the existing business by opening a departmental store to be run by his son who has completed MBA in retail management. The Supreme Court in instance held that the phrase required bona fide is suggestive of legislative intent that a mere desire wishes outcome of whims or fancy is not taken note of by the rent control legislation. A requirement in the sense of felt need, which is an outcome of sincere, honest, and desire. Contrary distinction with a mere pretense of or pretext to evict a tenant on the part of the landlord claiming to occupy a premises for himself or for any other member of the family would entitle him to seek ejectment of the tenant. Looked at from this angle, any setting of the facts and circumstances protruding the need of landlord and its bona fides would be capable of successfully withstanding the test of objective determination by the court. The judge of facts should place himself in the arm of chair. It is important. The judge of facts should place himself in the arm of chair of the landlord and then ask the question to himself whether in the given facts substantiated by the landlord, the need to occupy the premises can be said to be natural, real, sincere, honest. If the answer be in the positive, the need is bona fide. The failure on the part of the landlord to substantiate the pleaded need, or in a given case, positive material brought on record by the tenant, enabling the court drawing an inference that the reality was to the contrary and the landlord was merely attempting at finding out a pretense or pretext for getting rid of the tenant would be enough to persuade the court, certainly to deny its judicial assistance to the landlord. The Honorable Guwahati High Court, while deciding CRP number so-and-so, reiterated the views of the Supreme Court in such and such and various other judgments of the apex court and held that the bona fide requirement of the landlord has to be seen on the date of the petition, and the subsequent events intervening due to protected litigation will be relevant for molding the reliefs, provided such events have material impact on the rights and obligation. In other words, the question of bona fide requirement is to be adjudged as on the date of filing of the suit, and it is the burden of the plaintiff or the landlord to prove the said aspect of the matter if during the pendency of the litigation, if any subsequent event occurred which disentitles the plaintiff, landlord, to evict on the ground of bona fide requirement, it is the burden upon the tenant to prove that such bona fide requirement of the landlord has eclipsed, as it is the tenant who seeks This entitled the landlord to a decree for eviction on subsequent events. It would be clear that for the purpose of bona fide requirement of landlord, what is required is that it must be something more than a mere desire, but need not certainly be a compelling or absolute or dire necessity. So it should be, your lordship, it must be something more than a mere desire and need not be a compelling or absolute or dire. A bona fide requirement is something in between mere desire or which or one hand on the one hand and the compelling or other dire or absolute necessity on the other. In the instant case, the plaintiff averred that he has a son and a daughter, and both of them have completed their higher degrees. The son of the plaintiff has completed his MBA in retail management from Sikkim Manipal University, and his daughter has completed graduation in BSc IT. The plaintiff pleaded that his son is running a bakery confectionery along with a fast food counter, namely AB Enterprise, from the adjacent room measuring so and so. Attached to the suit room, which is flourishing and with passage of time, the plaintiff and his family members are intending to expand the existing business by opening a departmental store along with the present business by combining the suit room with the shop run by the plaintiff's son, for which the walls separating the two rooms need to be demolished. The plaintiff also pleaded that the suit room is also required to augment the income of the plaintiff and his family members. The plaintiff has produced Exhibit 3, that is the trade license that is in the name of AB Enterprise issued by the GMC. The defendants denied the suit. Premises room is bona fide requirement of the plaintiff for expanding his existing business and alleged that it is mere pretense to pressurize the defendant to agree to their demand of enhancing the rent at the rate of rupees 7,000 from rupees 2,500. The defendants exhibited certain certified copy of the plaintiff title suit number 273 of 2008. Exhibited certified copy of petition filed under section 23, rule 3, CPC Exhibit B, copy of evidence of Mithun Boisho, son of the plaintiff, entitled suit number 273, 2008, Exhibit D, in support of their contention. PW1, the plaintiff confirmed that the defendants were in occupation and possession of the suit room since 1973 as tenants. PW1 admitted that he had instituted title suit number 241, 2003 against the present defendant for ejectment on the ground of defaulter and bona fide requirement as the same were required for his son, and said suit was dismissed on contest. He admitted that he did not prefer appeal against the judgment and order passed in title suit number 24103. PW1 further admitted that in the year 2008, he again filed a suit number 273 2008 against the present defendant number 1 and Sitaram Purohit, since this is the other partners defendant number 1, for eviction on the ground of defaulter and bona fide requirement with respect to the same suit room, and later compromised the suit by filing joint petition Exhibit B. PW1 also admitted that along with the joint petition Exhibit B, he had also filed Exhibit 1, the tenancy agreement dated 4/1/2011, executed he also filed Exhibit 1, the tenancy agreement dated 4/11/2011, executed between him and the present defendant, and he received rupees 1,50,000 as salami. PW1 also confirmed that his daughter's marriage was fixed in the month of December 2019. So, Your Lordship, this is the wrong, Your Lordship, recording of statement, Your Lordship, that is Exhibit 1, the tenancy agreement dated 4/1/11, executed between him and the present defendant. This agreement, Your Lordship, was never produced in either title suit number 27308 or above. It cannot be so, your lordship, because it is of the year 2011. The earlier suits were 2003 and 2008. So this is not a correct recording of the evidence. 32. On perusal of materials on record, it is seen that title suit number 273 2008, the plaintiff showed requirement of the same suit shop room for use of his son to carry out business with an unemployed youth. Admittedly, said suit was disposed of on compromise with the parties executing fresh tenancy agreement dated 4/1/2011. Exhibit 1 fixing the monthly rent at rupees 2,500, which was enhanced rent. The Supreme Court in such and such held that in our view, the High Court ought to have considered the fact that in eviction proceeding under the Rent Act, the ground of bona fide requirement or non-payment of rent is a recurring cause of action. Is a recurring cause of action, and therefore landlord is not precluded from instituting a fresh proceeding. In an eviction suit on the ground of bona fide requirement, the genuineness of the said ground is to be decided on the basis of requirement on the date of the suit. On the date of the suit. Further, even if a suit for eviction on the ground of bona fide requirement is filed and is dismissed, it cannot be held that once a question of necessity is decided against the landlord, he will not have a bona fide and genuine necessity ever in this future, your lord. Ever in future. In the subsequent proceeding, if such claim is established by cogent evidence adduced by the landlord, decree for possession could be passed. So this decision, your lordship, was, I think, placed from our end, and this decision says that cause of action under the Rent Control Act is a recurring one, your lordship. What had happened earlier, that cannot be a bar for instituting a suit, your lordship, at the subsequent stage. Now the court is considering, your lordship, the suit of 273 of 2008. In the perception of that suit, your lordship, the court has given a finding here that this bona fide requirement is a mere fancy, not sincere, and it is a mere desire, your lordship. I'll be coming, your lordship. So this decision says, if earlier something happened, there was a suit that was dismissed, say, on the same ground, and on some later a suit is filed, same ground, your lordship, if it can be established by the landlord tenant, landlord and landowner, your lordship, then it should be considered in that perception, your lordship. The law being well settled as to the right of the landlord to come up with a suit for eviction showing genuine requirement of the suit premises, it is now to be seen whether the plaintiff had a bona fide requirement of the suit premises as on the date of filing of the suit. There is no denial by the defendant that the son of the plaintiff is running a bakery and confectionery along with fast food counter under the name AB Enterprise in the room adjacent to the suit room. DW1, that is defendant number 32, admitted that the plaintiff has a room adjacent to their shop room, and the room is smaller than the shop room. It is seen that although the PW1 denied that he demanded rupees 7,000 per month as rent money from the defendant after expiry of the tenancy period on 3/1/2016, it is the plaintiff who suggested DW1 that the present rent rate is not appropriate for the tenanted premises as per the market value, which was denied by the defendant. The suggestion put by the plaintiff to DW1 goes to show that the plaintiff is not satisfied with the present rent rate of the suit room fixed by the plaintiff himself by Exhibit 1, the tenancy agreement. So this situated, the plea taken by the defendant that the plaintiff demanded enhancement of rupees so and so, and on refusal of the agreed and the said demand, the plaintiff filed this suit cannot be discarded, and it can be inferred that the requirement sense of felt need is not an outcome of sincere and honest. So this is a hypothetical findings, Your Lordship. Imaginary finding, Your Lordship, just because a suggestion was given, Your Lordship, that you see it is an agreement in the year 2011, 4/1/2000. Now it is 19. From 11 to 19, Your Lordship, it is more than 9 years, Your Lordship. A suggestion was put forward that you say, as on today, this 2,500 monthly rent, Your Lordship, in the area of this Adgaon, this is Tokovari, Your Lordship. Adgaon, Your Lordship, this is 80 road, Your Lordship, in the chalk itself, Your Lordship. Main chalk, Your Lordship. 2,500 for 550 square feet of premises, Your Lordship. It is a mega amount, Your Lordship. So can I not express that, Your Lordship, that what rent was fixed in the year 2011? So that is not the proper rent as on today in 2019. Otherwise also, Your Lordship, on 3/1/16, it has expired, Your Lordship, the tenancy has expired by a flux of time. From that angle also, Your Lordship, a suggestion has been put forward, and that has been taken as a lever for giving a decision, finding, Your Lordship, that my bona fide requirement is not genuine, not sincere, it is a fancy. So it is hypothetical, Your Lordship. It is imaginary and based on no evidence at all, Your Lordship. That evidence, that finding cannot be accepted by this honorable court, because that finding is not finding based on evidence, Your Lordship. It is a hypothetical. A suggestion given during cross-examination, can it be relied upon by a court, Your Lordship? Even that cannot be relied by the parties during argument. A suggestion is a suggestion. If something I fix 10 years back or 20 years back, can it be justified that today also it is correct, it is proper, Your Lordship? Definitely, Your Lord. Definitely not, Your Lordship. At 2,500 monthly rent, Your Lord, in Tokovari area, sometime in this 80 road RCC building, Your Lordship, ground floor, 550 square feet. Just because I have expressed, it is not my case, Your Lordship, in the pleadings or in evidence, it is during cross-examination, that you are, so far the rent is concerned, that it is actually at a lower rate, and it is not actually reasonable rent. So he said, no, it is correct. 2,500 DW1 is admitted that it is correct than 2,500 rent. That was suggestion, and that suggestion has been converted into a positive evidence, Your Lordship, and it is a basis for giving the finding that there is no bona fide requirement. Can it be so finding, Your Lordship? Can be so that sort of finding, Your Lordship, even from the appellate court, which has been accepted by the trial court, Your Lordship, by giving reasons.
Okay.
Now, Your Lordship, this is the finding, this is the case so far bona fide requirement is concerned. On this point, Your Lordship, I am citing some decisions, Your Lordship. So the finding given is very casual, Your Lordship. It took you a little. So, ready to so more keta koi. More keta nahi. Ek minute. Ready to dia sun. 2002 5 SCC. Aru dia sun, aru di dia. Ekelage dia. Raba. 2008 9 SCC dia sun. Two 2008 SCC disa. Dia 2009 SCC 329. Your Lordship, before that, may I take Your Lordship through the evidence, Your Lordship? It is
No, not necessary.
not necessary. Your lordship will go through.
Okay, okay.
So,
So
para
you,
24.
now you tell me in
Para
this
24.
decision,
Para 24.
2009 SCC 329.
202, 5 SCC 397. 2002, 5 SCC.
Yes.
Page
Which paragraph,
397. Your
which
lordship,
paragraph you have relied upon?
paragraph 24.
24.
24.
Okay.
Lordship got it.
Yes.
We are of the
No,
opinion that
no, not necessary to read out. I will go through it. And in the other judgments, which paragraph you have relied upon?
your lordship, the other decision, your lordship, 2008, 9 SCC,
Yes.
page 699,
Paragraph number.
paragraph 18, 19, and 20.
Okay.
So may I read it, your lordship?
No, not necessary.
So third decision is your lordship. 2008,
Yes.
9 SCC, 699. 699. Then your lordship, the other decision is 2009 SCC 329.
Paragraph number.
Paragraph 6, 7, and 8.
Okay.
Now, your lordship, on renewal, on indefinite period, I am coming, your lordship. It is a very important decision, your lordship. That is, after a tenant become tenant at sufferance, what will be his position, your lordship? Now it is 1995 person. SCC 698. তাহলে আরো একটা দিয়ে দিয়েছুন এই ভেরি টু দিয়েছুন মরে এই ভেরি টু দিয়েছুন টু 2018 1 SCC একটু মত দেয়া ওটা স্যার স্যার
Yes.
Lordship, I am placing this 2018 2 SCC, page 21, paragraph 13 and 14. Your lordship. 13, as pointed out earlier, on 9/4/1979, the landlord issued a notice to the respondent tenant seeking vacant possession of the demised premises on account of determination of lease due to efflux of time. After lapse of lease period, if a lessee continues in possession of the demised premises in absence of an assent by lessor, then he is a tenant by sufferance and exposes himself to be sued for ejectment at any time without any prior notice or demand of possession. Now, your lordship, part 14, the term in the lease agreement for renewal of lease does not ipso facto extend the tenure or term of the lease. I am repeating, your lordship, the term in the lease agreement for renewal of lease deed does not ipso facto extend the time, tenure or the term of the lease. So far as the clause for renewal in the lease deed is concerned, it was held in DDA versus so that such covenant only entitled a lessee to obtain a fresh lease in accordance with and in due satisfaction of the law governing the making of a lease. In the absence of renewal of rent agreement, in our considered view, the possession of the respondent tenant in the demised premises has become unlawful and they are liable to be evicted. Here in this case, it is important in view of the fact, your lordship, they are saying it is automatic. The Supreme Court says, no, it is not automatic. There must be an agreement after expiry of the earlier one. If there is no renewal agreement after the expiry of the first one or the previous one, in absence of that, any renewal agreement, your lordship, in that case, his position is as tenant at sufferance and his is liable to be evicted, your lordship, he being unlawful possessor or a trespasser. So that the clause 4, your lordship, in the agreement, your lordship, that it would be automatic, it is axiomatic that it will be renewed, your lordship. That is not the proper interpretation of the clause.
Okay.
That can't be so.
Okay, in the next judgment?
Your lordship, next judgment, your lordship will find. So as per this decision, your lordship, that clause, your lordship, is no clause, your lordship, in the eye of law. So if you want renewal, it must be a renewal, your lordship, on black and white. There must be an agreement, your lordship, phrase, same conditions, but there must be a phrase. But with the dissent of the landlord, there cannot be an automatic renewal of the lease. With the dissent of the landlord, your lordship. It is very important, your lordship, and this will decide the matter, your lordship, entire matter. Now they are actually harping upon the clause 4 of the agreement, that is the exhibit 1. Now next document, your lordship, I am relaying decision, your lordship, that is, yes, 4 is not. For your lordship will find is our 1995 5 SCC 698. This one it was. Your lordship. 1995 5 SCC 698. Got it, your lordship.
Paragraph number.
Paragraph 8 and 13, your lordship. So your lordship, just now the other decision says that a person after the effects of time limited by the agreement or the lease deed, your lordship, if he continues, then he is a tenant at sufferance. So his position is like that of trespasser or unauthorized occupier, and he can be evicted. Now they are depositing rent in court. Whether it is legal or illegal, that need not be decided by your lordship or the trial court as well as the first appellate court, because he has deposited the rent in court against my will. I am not giving any consent without tendering that to your lordship, not in a proper manner. Just they have actually exhibited some challenge, your lordship, and the cases challenge, your lordship, and that is beyond the expiry of the tenancy period, that is 4/1/2011, 3/1/2016. Beyond whatever they have made, that will not renew the agreement, your lordship. That will not renew the lease or tenancy, your lordship. It is up to you why you have deposited. Already in the month of September and October 2015, when they came to tender, your lordship, came to deposit rent with me, your lordship, pay rent, your lordship, to me, your lordship. I want them that there will be no renewal after 3/1/2016. That is, since the month of January 2016, there will be no renewal. That is there in evidence, your lordship. Specifically, we have told them that there will be no renewal. So you need not pay any rent since the December 19, 2015, you did not. Therefore, because it is required for me, for my son, for my daughter and other family members to expand my business, to augment my income. So to augment income, your lordship, that is also a ground for eviction. Supreme Court decision said, your lordship, that if somebody wants to enlarge his business, your lordship, by taking the nearest room, your lordship, 2-3 rooms, your lordship, there is no bar, your lordship, there is no fetter. He can do that. Now your lordship will come, paragraph 8, a tenant at sufferance is one who comes into possession of land, paragraph 8, your lordship, of 1995 decision. 698. Para 8, your lordship. Got it, your lordship.
Yes, already you have
Lordship,
submitted one decision.
Lordship, just one line I am. The tenant at sufferance is one who comes into possession of the land lawful title, but who holds it by wrong after termination of the term or expiry of the lease by a lapse of time. The tenant at sufferance is therefore one who wrongfully continues in possession after the extinction of the lawful title. There is little difference between him and a trespasser. There is little difference between him and a trespasser. In Mullah so-and-so, the position of tenancy at the transfer of property so-and-so, position of a tenancy sufferance has been stated thus. A tenancy at sufferance is merely a fiction to avoid continuation in possession operating as a trespass. It has been described as the least and the lowest interest which can subsist in reality. It therefore cannot be created by contract or arises only by implication of law. When the person who has been in possession under a lawful title continues in possession after that title has been determined without the consent of the person entitled. A tenancy at sufferance does not create the relationship of landlord and tenant. It does not create any landlord and tenant. So that being the position, your lordship, after the expiry on 3/1/2016, there is no relationship. So his deposit of rent in court, without there being any relationship of landlord and tenant, it is no deposit, it is up to him why he has taken the risk. Therefore, your lordship, on both the counts, your lordship, the plaintiff petitioner has a very strong case. He is a defaulter and they are tenant at sufferance, and there is bona fide requirement, your lordship, that unless the space occupied by room, occupied by them, I get, your lordship, then I will be confined forever, your lordship, with the 275 square feet room, your lordship, with so many business, it is not possible. So,
Yes, Mr. Sahayawala.
First thing, my lord, what my lord is saying, my lord, that clause 4 is, my lord, hit by section 29. My lord, I don't so, my lord, section 29 is absolutely different purpose. Examples are given that one person wanted to sell oil, but he had not given them oil, what type of oil. Then it is big. My lord, that contract act itself has given in the definition, the examples are there. How, my lord, that will apply here? I do not understand. Uncertainty. What is uncertainty? A agrees to sell B 100 tons of oil. There is nothing, whatever, so what kind of oil was intended. the agreement is void for answer. This is the type, my lord. This is not the question, my lord, here. And what is my learned friend relying on transfer party, a grand control like this, my lord, different. My lord, where the question of sufferance, the agreement itself, my lord, proves that no fresh agreement is required. My lord, my learned relied on the judgments. The judgments are on the facts of the case. In those judgments, my lord, your lawsuit will find, my lord, that the agreement is that a fresh agreement is to enter into. Here, the agreement is very clear, my lord. Clause 4 of the agreement, if your lawsuit will see, that automatically. And they have evidence also, my lord, they say that it will be automatic. 15% increase of the rent every 5 years.
Then till when it will continue?
Well, whenever they will evict, my lord, Rent Control Act provides section 5. As per the Rent Control Act, they can evict me. Otherwise, it will continue. My lord, I am tenant since 1973.
No,
Last-
whether for indefinite period it will continue.
My lord, yes, Rent Control Act, my lord, in fact, my lord, this agreement for 5 years, it is to be registered, but it is not registered. So it is not the agreement I have law, my lord. Only to some other purposes it can be relied on. Now the question is this, here,
So the agreement was not registered agreement.
not registered agreement. Now, they themselves, my lord, they have stated that, yes, it will continue. No fresh agreement is required. That is the main crux of the matter. My lord, every time, my lord, what happened, this is the habit of the landlord. They file a suit, they will increase the rent. Last time, my lord, in 2008, rent was 1,214 rupees. They doubled the rent, 2,500. Prior to that also, 2003, my lord, they filed a suit. That suit was dismissed. 2008 suit was compromised. Rent was doubled, more than doubled. And in that suit also, he has taken the same plea that this suit house is required for his son. Well, your lawsuit will see, I shall place well, that a bona fide requirement must be bona fide, my lord. That is the question here. Here it says, without any press agreement, without any press agreement. This is very, I am harping it. It shall be renewed automatically without any press agreement. So there will be automatic renewal, my lord. Since 1973, I am the tenant, my lord, in this house. And 2008 also, my lord, the same plea was taken that this house is required for him and his son. Then what happens? Well, they have given it.
After reflex of several years, whether he can
My lord,
take the same
why the
plea
new ground, my lord. His daughter is married in December 2019. He himself has said, 2019 his daughter is going to be married. If you also see, my lord, he filed another suit, my lord, against Anand Motors. He said, my lord, that in the evidence comes, bona fide is that same plea has been taken. I, along with my father, took the plea that premises is required bona fide, so and so, run the business. And moreover, my lord, here your lawsuit will find, my lord, that even the trade license was not renewed after 2017. If your lawsuit will see the evidence of P2, my lord, cross-examination part.
Is it the part of the main petition, CRP? No.
No. There's no evidence.
Cross-examination of
P2.
Yes.
Your losses may come to page 2, my lord. I know that my father, third sentence, my father received rupees 1,50,000 from the defendant as a premium. My lord, my learned friend has also argued that, well, this is barred under rent control, like, where is it barred? There is no question of barring, my lord. Salami is being taken, my lord, nowadays also. Premium. That amount is still with my father. I know that Exhibit 1 was for a duration of 5 years. But not of the agreement. The tenancy agreement is to be renewed automatically after expiry of 5 years without any fresh agreement. As per clause 4, agreement rent will be enhanced 15% automatically after lapse of 5 years without any notice to landlord. As per clause 4 of the expiry of the every 5 years, the existing rent is enhanced 15% without notice. Now, page 3, my lord. He executed a power of attorney, father executed a power of attorney in favor of that has been executed Exhibit 2. Page 3 of this clause. As per clause 3 of Exhibit 2, I have been empowered to enter into an agreement or a contract with any persons authorized for utilization of the said scheduled property or to lease out the same. Well, the authorization is given, my lord, to lease out the same or allow someone to use the same temporarily or take back possession. As per clause, I was not authorized to execute all deeds. My father has not authorized me to run my business from the said tenanted premises. This is something. As per Exhibit 3, trade license of the same is not renewed since 2017. My lord, the evidence is given, my lord, much later. They are not prudent businessmen also, my lord. They say that this is, my lord, so this evidence is of 19 August and now trade license is 2017. I submitted my affidavit on so and so prior to suit. There's another suit filed by my father on 2008 against Orient Motors. In that suit, I deposed as P3. Through that, by filing evidence of affidavit, I said that the present in question is required for my running business and thereafter with my father. Same plea taken against that other case. I have not submitted any document of my existing business to show that father existing business. The present of business heavy enterprise is run by me as well as my father. Similarly, my lord, father has also said same thing, my lord. The PW1 also said in that clause same thing, my lord, that it is to be renewed automatically. And they have taken salami, my lord. No, my lord, my commission is this, my lord. These are the pleas, my lord, for enhancement of rent. They have suggested, my defense says that cannot be considered. Yes, why then sanction is given? Sanction has been given, this is present rent is not proper. Let them file a petition under rent control act. There is a provision under rent control act to fix the standard rent. They know that if they file the petition for standard rent, that will not be increased because they are charging more than that for that premises. Every time they put the tenant on pressure and then enhance the rent. This time they wanted to enhance the rent to 7,000. This is the question, my lord. And he refused to accept the rent, my lord. After 3-1, my lord, he refused to accept the rent. He himself has said, my lord, the tenant number 1, PW1. So where is the question of, my lord, father, my lord, producing the check or other things, my lord? And our High Court has said, my lord, once a refusal, my lord, the subsequent refusal is not required. I can place that judgment also, my lord. For 2 GLT. Earlier also it is there, that has been relied on here. 2014, 1 GLT 252, my lord. Paragraph 22 to 25. My lord, the earlier judgment was also there, Justice Vansina, that has been relied on here. It held, my lord, that once a refusal is there, my lord, every time, my lord, it need not be tendered.
Which paragraph you have relied
Paragraph
upon?
22 to 25. 22 to 25. 22 to 25. This one, my lord, just the issue, my lord, the earlier this one also, my lord, I have, my lord, if you wanted to see, my lord, that 85, my lord, judgment. Giving another, the same. This is, my lord, 86, 1 DLR. This is the same, my lord. Paragraph 5. Paragraph 5. And here the facts are this, my lord. The plaintiff asked him to vacate the premises after third. My lord, he did not, my lord, allow him, my lord. He asked the plaintiff to vacate the premises. There is no question of accepting the rent, my lord. So the question of, my lord, again, my lord, going to the plaintiff and to come to him to give the rent, my lord, does not raise at all, my lord. Once he has refused it, so every time he did not go there, my lord. Another aspect, my lord, regarding so far bona fide requirement is concerned, my lord, I shall place 2-3 judgments of the lord. Only 3 judgments I am placing, my lord. First one is, my lord, 2001 5 SCC 705. Paragraph 15 and 16. Paragraph 15, my lord, at page 710, the last subpara, my lord, dear lord. Last subpara. The legislature, in enacting the provision, has taken the ample care to avoid any arbitrary whimsical action of a landlord to evict the tenant. statutory mandate is that there must be first a requirement of a landlord, which means it's not a mere whim or fanciful desire by him. Further, such requirement must be bona fide, which is intended to avoid a mere whim or desire. The bona fide requirement must be in percentage and must be manifested in actual need, which would be evidence the court that it is not a mere fanciful or whimsical desire. This intent is made further clear by making the provision that the landlord has no other reasonably suitable residential accommodation for his own occupation in the city or town, so and so and so. Well, this is not. Now paragraph 16, same thing. So now this 1992 2 GLR page 36, paragraph 22, 23 and 25. The same line, my lord. 92 2 GLR, paragraph 22 onwards. Twenty-three may be seen, my lord, here. Placing much, my lord, your office may see. Bona fide requirement of landlord should be genuine and honest, conceived in good faith, and the court must also consider. Here, my lord, the existing business license has not been renewed to 2017. Court must consider it reasonable and gratify the need. The landlord desire for possession, however, honest, it might otherwise be inevitably a subjective element in it. Desire become a requirement of law, must have an objective element of need. Then relying on this decision, the learned counsel and the petitioner submitted that while granting a decree for eviction, ground of bona fide requirement contained that this must be satisfied from the evidence on record that there is a genuine need of the situation. So every time, my lord, they come with such plea, my lord. This is there. And then 95 3 GLT also same, my lord. Here paragraph is not there. Page 188 and 189. 188 last subparagraph. And 189. Same, my lord, line, same line. This should be honest, good faith, everything should be there, my lord. So every time, my lord, the last time also, they filed a suit and then they compromised it.
Last time is when?
2008, they have filed a suit. Yes, I'm coming to that.
8 and 16 year
Let me-
lordship, 8 years.
Yes, let me see.
Don't
let me see.
suppress fact.
I'm not suppressing fact.
Then
2008,
don't
they have-
suppress fact.
they have filed a suit and that suit, my lord, they have compromised it later on. And that suit was also for the business of his son. They filed another suit against one another tenant also. In that also same plea has been taken. So my lord, what?
No. Is there any bar taking the same plea in subsequent suit?
Well, he has only started a business, my lord, and he has not shown, my lord, where from the money will come. Nothing, my lord, genuine need. That is why, my lord, what others said, my lord, he must show where from the fund comes, what type of business, my lord. Can my lord, they have said, my lord, that they will do a business of this unjust. He should, he employ, who needs to take question at that. departmental store, my lord, 500 square feet, my lord, departmental store cannot be, my lord. They say, my lord, and where from the fund come, where, nothing has been said. These things are very much required for this purpose.
Okay.
My lord. My,
Yes, any reply?
my lord, learned court, my lord, has directly, my lord, come to a conclusion that, my lord, they are not satisfied with the rent. They wanted to enhance the rent, my lord, every time, because earlier also we have seen their conduct, and that is why that has been considered by this, by the court also, my lord, and suggestion also given, my lord, that this rent is not as per the market. And why they have not filed the application under the rent control act for standard rent?
Okay.
Lordship, my reply would be, so far clause 4 is concerned, your Lordship, my land friend, that it is section 29 is not applicable. Very good. But so far decision, that is 2018 2 SCC page 2 is concerned, paragraph 49 8, that is applicable. That decision says only one line, your Lordship.
Which decision?
That 2018 2 SCC 2 your Lordship, 14, para 14, your Lordship. The term in lease agreement for renewal of lease does not ipso facto extend the tenure or the term of the lease. So far as the clause for renewal is concerned, it was held in so and so that such covenant only entitles a lessee to obtain a fresh lease in accordance with law. In our considered view, the possession of the respondent tenant being in the demised premises has become unlawful and liable to be evicted. So that decision is applicable, your Lordship. That decision says that there is a clause, renewal clause in the agreement, but it has not been renewed in black and white. Then he can't claim that renewal must be given without the document, your Lordship. Here also, your Lordship, without the document of extension of the tenure, he can't claim that the clause will extend for all times to come, your Lordship. This is uncertain and indefinite for indefinite period. So that is not applicable, your Lordship. This decision will take care of this. Now, your Lordship, another point my letter friend has read. So for 2003 case is concerned, your Lordship, at that time he was tenant, no doubt, but under the joint family. Your Lordship will find from the evidence, joint family. At the stage of 2003, your Lordship, we are two minors. This daughter and the son, your Lordship, two minors. In 2008, evidence is there, your Lordship, we were college students. So the father, your Lordship, can't take the risk that they should not study, your Lordship, harder, your Lordship, and they should be put in business. Leave was taken. Anyway, your Lordship, that was a compromise matter in the year 2008. In between 2008 and 2016, much things has changed, your Lordship, and one matriculate, your Lordship, he will pass out MA, MSc, your Lordship, MBA also, your Lordship, MSc, LLB, your Lordship, medical and engineering degree also, he can take within that 8 years of period. Now they are harping on 2008 and 2003. So Supreme Court says that on the date of petition filing, whether there was bona fide requirement or not, that is the Supreme Court. They can't, your Lordship, give a goodbye to all decisions by showing the High Court decisions, your Lordship. Supreme Court decision says that the court will consider the bona fide requirement on the date of filing the suit, and thereafter, your Lordship, they will consider it till the date of passing the decree or the judgment, your Lordship. So at that time, your Lordship, after the institution of this suit, your Lordship, so we become competent, your Lordship, MBA degree and BA IT, your Lordship. So we are competent to run business, your Lordship, independently. Now, my lord, why he is actually harping on that license. License can be purchased, your Lordship, within an hour. If I go to the GMC office, that I need a license, In place of 100, if I give 500, your lordship, in an hour it will be given, your lordship. My learned friend knows all these things. So it is not a difficult thing. License can be obtained, your lordship, even after doing the business, because I am running a business. From that business, your lordship, if further license is required, your lordship, that is not their headache, your lordship. And my learned friend is arguing, your lordship, monetary position. Where is the law that I must show the money, give an account to the court, your lordship, that this is the money in the bank, in my father's account and is my account, your lordship. These are the amount actually lying idle. So if I start the business, there will be no problem. Is there any legal provision, your lordship, the money is to be sought before the court? These are futile argument. Actually, it has been advanced that monetary part, this license part, everything, just to sway the mind of the court, your lordship. To attract the get the sympathy of the court. The so far learned appellate court is concerned, your lordship, findings are all hypothetical, imaginary, your lordship. Hypothetical and imaginary findings, your lord, that cannot take the place of real finding and cannot take the place of law, your lordship. That cannot take the place of law, your lordship. Money is no material matter, your lordship, nowadays. Money can be, nowadays, your lordship, car can be purchased without money. Flat can be purchased also without money. Everything can be purchased without money because bank is ready. They have opened so many counters, your lordship, today.
Okay.
That's why, your lordship, this consideration does not come because these are otherwise also beyond the records.
Okay.
And this is a fit case, your lordship, on both the counts. Actually, it is expected the decree, the suit will be decreed, your lordship.
My lord, landlord and tenant, my lord, the definition includes the legal heirs also. Legal heirs also. My lord, divisional jurisdiction, my lord, your lordship may not interfere.
Okay. Heard Mr. Esalli, learned counsel for the petitioner, and Mr. Lee and Chayola, learned senior counsel, assisted by Ms. Bhattacharjee, learned counsel for the respondent. Argument concluded, judgment reserved.
Much.
Standing 28. Standing 28.
My lord, their statements, my lord, I have trademark. And only one paragraph, if my lord, no translate record, I can read up. My lord, only one paragraph, just I can show, my lord. And if required, I can make it translated, my lord. If required, my lord, I can make it translated, my lord. But if I read over, my lord, it may not be necessary. Only, my lord, I am reading, my lord.
No, no, in connection with that section 20 or not that rule 27 C 4.
That rule is not mentioned, but statement of the other witness, 10 witness statement is available. I have trademark and statement of the petitioner. One is confessional statement. That is another thing. Separate statement also there, my lord. And
No, the question is whether that statement was recorded in compliance of this rule 27 or not.
in compliance of rule 27 or not, my lord.
Because there may be many other statements, and you cannot show each and every one statement that was recorded under this provision. Because you have imposed this major penalty.
Yes, Niyam 27, yes. As per rule 27, my lord. Yes, my lord.
Is it written there?
Yes, my lord. Yes, बल संख्या स्वयं जेपी नाथ को दिनांक इनमें पूछे गए तथा द्वारा किए गए उत्तर as per 49 के धारा 11(1) of the मतलब एक्ट and नियम 27 के प्रावधान के तहत, like 27 means this, नियम means rule. As per rule 27 and as per section 11(1) of the act. That is given, and just only one paragraph, 3 lines. I may से 20/12/2014 से तैनात था, ड्यूटी में तैनात था दिनांक 30/11/17 को रात 1900 आवर्स से 2100 आवर्स तक ड्यूटी में था, ड्यूटी में तैनात था। मैं अपनी ड्यूटी के दौरान घरेलू समस्या के कारण मानसिक तनाव में था, इसी कारण मैंने शराब पिया था। And that the learned senior counsel has argued that regarding he is in duty for 3 days and because of that मतलब he is taking alcohol, that is not his person। मतलब he has taken that मैं घरेलू समस्या के दौरान मानसिक तनाव में था, इसी कारण मैंने शराब पिया हुआ था और मशा के अंदर से सो गया था। That is and subsequently questional he has put to some question also, he has answered it again। he has stated that आप अपने ड्यूटी के दौरान क्यों शराब पिया था? श्रीमान घरेलू समस्या के कारण मानसिक तनाव में था, इसी कारण मैंने शराब पिया था। So मतलब only that much is answer मतलब।
You mark it.
I flag mark it मतलब his statement and statement of the other witnesses also मतलब and it may not be constructed मतलब only one paragraph मतलब may go through मतलब if required subsequently I can make it constructed।
Okay.
So far as that consumption of alcohol is concerned, my learned senior has already explained that he might have consumed while he was not on duty. So duty hours he did not consume. That my learned senior has already noted.
Heard Mr. Sharma, P.N. Sharma, learned counsel for the petitioner, and Mr. Sir, learned CGC for the respondent. Argument concluded. Judgment reserved.
Obliged.
And number 8.
May it please your Lordship, my lord. This is on first appeal, my lord. What happened? I was the defendant in the title suit, my lord, money suit, my lord, where it was ex parte. Ex parte decree was passed against this, my lord, defendants. Now the defendants are petitioner before lordship because when they received the execution notice, then only they came to know that there was a decree, ex parte decree. Then, my lord, they have filed one petition that was dismissed. Then thereafter, I have filed this, my lord, first appeal along with condemnation petition. Now there is a delay, my lord. This delay is genuine one because from the date of decree till, my lord, we have received the notice of the, my lord, execution case. We have no knowledge. Therefore, my lord, now lordship may kindly page 9, the order at page 9 of the IA 3368 2019. Here, my lord, this was the order passed by the learned civil judge, my lord, Kamrup at Amingaon, civil judge Kamrup at Amingaon, my lord, because we filed one petition under Order 9 Rule 13, read with Section 151 CPC. This was rejected because, my lord, here the Honorable Trial Court has held that as the
No, Mr. Goswami, this application is under Section 5 of the Limitation Act.
Limitation Act.
You show me the grounds.
Grounds, yes, my lord, at page 6, page 5, paragraph 6. That the petitioner received the notice of the execution case on 10/8/2023 and thereafter they went to the chamber of the advocate. As per the advice of the advocate, filed the petition under Order 9 Rule 13, read with Section 151 CPC, and on 1/9/2023, the petition was dismissed by the civil judge Kamrup on 18/4/2024. The certified copy of the order dated 22/5/2023 received on 30/4/2024. Thereafter, the petitioner, number 1, as per the advice of the advocate at Nolbari, decided to contest the order dated 22/5/2023 in the before the Honorable High Court on 3/5/2024. Serially, my lord, the petitioner and the said advocate of Nalbari came to Guwahati and discussed about the said appeal to be filed before the Honorable High Court on 5/5/2024. Thereafter, as it took 1 week time to study the case records, and as per the advice of the advocate of the High Court, petitioner applied for the certified copy of the some vital documents which were relied upon by the plaintiff on 16/5/2024, and the same were received by the advocate of the petitioner Kamrup District Amingao Court on 5/6/2024. Serially, we have Milord explained. Thereafter, the said advocate delivered the said certified copy, a bunch of documents to the advocate of Guwahati on 12/6/2024. The advocate of the High Court, after receiving the copy of the said documents, prepared the regular first appeal along with the stay application, and after receiving the cost of the filing with the court fees, etc., Milord, filed the same on 10/7/2024. However, the certified copy of the order dated 6/4/2024 in MJ case number 315 of 2023 found to be not very legible, and therefore again they have applied for the certified copy on 19/9/2024 and received the same by the advocate Amingao on Iman and handed over it to the advocate of the High Court on 25/9/2024. Therefore, there is a delay in filing the appeal, and the cause of delay is explained as far as possible for the kind consideration of the Honorable Court. Here, my lord, we have stated that there is no any intentional delay and negligence on the part of the petitioner, this appellant, my lord, because this 546 days delay without our knowledge, my lord, because the Honorable Court at the time of passing the decree, my lord, has held that there is a track report. On the basis of the track report only, my lord, it is held that no the notice is served upon the defendants, my lord.
So where is the bar in accepting the track report?
Track report, my lord, what happened? Here, even we in the High Court.
Tell me where is the bar in accepting that track report?
No, Order 5 Rule 19 also, my lord, it appears that, my lord, track report in some Supreme Court judgments also there, my lord. Because it was only a printed copy. It was not proved by the postal department, my lord. Nobody came. Only this was produced that this is service is complete, and it was held to be the complete service, my lord. Therefore, my lord, my humble services, let us appear before the Honorable Court below and file our WS and the evidence, because it's a matter of several lakhs of rupees, my lord. Because the defendant number 1, he died. This is a, my lord, proprietorship concern. When as soon as the proprietor dies, my lord, the business also, my lord, finishes. There is no existence of the business of proprietorship concern as soon as the proprietor dies, my lord. The proprietor is also a party to that, my lord, suit, money suit. Now, my lord, what happened? This petitioner, the present petitioner, is the wife of that proprietor. There is definitely some, my lord, amount we have admitted. Some, my lord, amount is due to the, my lord, plaintiff. But the real fact is this, my lord, the amount along with the manager of
we are not merit on the merit of the petition. No. We are only on the grounds for
no, my lord, there are several
file the appeal within the stipulated period.
Yes, yes. My lord, several decisions of the Honorable Apex Court is also there. When there is merit in the appeal or in the, my lord, suit, Honorable Court may kindly consider the condone the delay, my lord. Because this amount is several lakhs of.
But Mr. Bhusami, you see, with the influx of time, one right is created in favor of the other side.
Yes. Now, my lord, they have filed and the execution case is proceeding, my lord. They have issued writ also, my lord. Now, against that, my lord, we have filed one petition also, I also, to stay. Because, my lord, as soon as this execution is completed, my lord, we have nothing to do, my lord. Everything will be loose, my lord. Now, what happened, my lord? Our considered, this fact is this 545 days, when we have explained it sufficiently, my lord, your lordship may kindly condone the delay and admit this appeal.
Yes, what is your submission?
Lordship, the petitioner in his delay petition in paragraph number 5, 6, 7, and 8 has laid their causes which caused them to cause delay to file the application. Kindly peruse paragraph number 5 of the IA, my lord. Paragraph number 5 of the IA, it has been stated by the petitioner that the proprietorship firm with Afzal Ali of the Afzal Ali proprietorship firm died on 4/6/2020. And thereafter the said proprietorship firm has been extinguished. This is a false and misleading avowment, my lord. My lord, I have filed my written objection wherein annexure number 12, page number 71. I have annexed the GST statement, my lord. GST was active at the time of issuing the legal notice by my side at the time of institution of pre-mediation against the present petitioner at the time of institution and the entire trial of the money suit. The GST was active, the firm was active, they were paying the regular returns. And at the time of filing of the execution petition also, the GST was active and return was paid. So the plea taken by the petitioner in paragraph number 5 is not sustainable. Moreover, my lord, in paragraph number 6, they have stated that petition under order 9 rule 13 read with section 151 of the CPC was filed on 1/9/2023. So may I please, my lord, to peruse order dated 12/10/2020, which I have annexed it. Annexure 14, page number 89 of my objection. Page number 88 is also relevant part. Decree holder is represented and submitted postal receipts along with tracking report against the judgment chapter number 1 and 4. Seen the petition number, white number so and so under order 9 rule 13 read with section 151 of the CPC. Filed by the defendants prayed to set aside the ex parte judgment and decree dated so and so, giving the petitioner an opportunity to contest the suit by filing written statement and adducing evidence. Registered the same as a separate miscase number 315. Case number 89, my lord. Seen the prayer of the petitioner so and so, same order, my lord, and the miscase was registered as miscase number 315/2023. In paragraph number 6, they have stated that case was filed on 1/9/2023. The instant miscase was filed on, it is their avowment, my lord, 1/9/2023. But the trial court record states that miscase was filed on 12/10/2023. They have covered up the delay of 1 month, misleading this honorable court, my lord. Then they have also stated that the miscase was rejected on 18/4/2024. That means, my lord, they have again misleaded this court. The miscase was actually rejected on 6/4/2024, page number 62. 62. And while rejecting the this instant miscase, so now they have stated that miscase was registered on 6/34/2024, while it was actually rejected on 6/4/2024. So again, the delay of 24 days has been covered up by misleading this honorable court again in the second date. So near about 3 to 4 months has been covered up, my lord, by making false dates in the petition, my lord. Now, my lord, my humble submission before your lordship is that there is a delay of 546 days, my lord, and while rejecting the petition filed under order 9 rule 13 for setting aside the ex parte judgment, the learned trial court has observed page number 62 annexure 10 of my written objection. I may be allowed to read this order, my lord. This is very important. Both the parties are represented. The date is fixed for passing of order on the petition number 4107 of 2023 filed by the petitioner defendant under order 9 rule 13 read with section 151 of the CPC. The petitioner have contended that the defendant number 1 had expired on 4/6/2020 and the petitioner are the legal heirs of one deceased defendant number 1. The petitioner have submitted further the defendant number 3, who is a minor who shall be represented by the defendant number 2. The petitioners have pleaded that the petitioner did not receive any summon from this court and hence they did not appear and contest the money suit filed against them. And on 10/8/2023, they had received the notice of the money execution, case number 1 of 2023. And then the petitioner contacted their engaged counsel and to know that a money suit filed against him has been decreed ex parte by judgment and order dated so and so. The petitioner have contended further that the non-appearance of the petitioner before this court was owing to no receipt of the summons and not due to willful negligence, and therefore they ought to be given an opportunity to contest the suit by filing the written statement, and they will be prejudiced if the same is not allowed, and therefore the prayer for setting aside the judgment and decree dated 22/5/2023. The OP has contested the instant case and has submitted his written objection, whereby the OP has raised the contention that the grounds shown by the petitioner lacks merit and should be rejected. The OP has contacted that the OP had received the summon issued by this court and have made a false assertion with regard to it thereof. That apart, the pre-mediation cases number 54/2021, and therefore the petition should be rejected. Heard both the side, peruse the case record. The learned counsel for both the petitioner has read contention that the petitioner did not receive any summon from this court for which they could not appear, and therefore the suit proceeded ex parte against the ex parte judgment and decree and was also passed. The learned counsel for the petitioner have contended further that they should be given an opportunity to contest the suit. On perusal of the case record of money suit case number 2/21, it is seen that the address of the petitioner, this is very important, my lord, it is seen that the address of the petitioners of the instant miss case has been shown to be the same in money suit number 2/21 and money execution number 1/23. And the petitioner have duly received the notice issued to the same address in the money execution case, after which they have appeared before this court and filed the instant petition. Summons were sent in money suit case number 2/21 to the same address, and tracking report clearly shows that summon to defendant was duly served, on the strength of which my learned procedure had ordered the suit to proceed ex parte against the petitioner. In such a scenario, the petitioners claim that they did not receive the summon does not appear to be sustainable. Moreover, the OP had filed a pre-mediation case bearing number 54/21 against the petitioner before District Legal Service Authority Kamrup Amingaon, in which the petitioner had received the notice but had not appeared, and therefore it cannot be said that the petitioner did not have any knowledge of the filing of the money suit case number 2/21. Money suit 2/21 had already decreed in favor of the OP, and in order to set aside the ex parte judgment and decree, sufficient cause has to be shown for non-appearance of the defendant, for which the suit had proceeded ex parte against them. The petitioner of this case have, however, failed to show that they were prevented by sufficient cause from appearing before this court in money suit number so and so. The ground cited by the petitioner lacks merit and therefore is rejected. A missed case is disposed. So, my lord, they have received the summon at the time of sending of legal notice by the counsel of the respondent. Thereafter, the respondent instituted pre-mediation case. There they appeared, they paid a part payment, 3 lakh rupees, my lord. And they have admitted in paragraph number 4 also, my lord. Kindly peruse paragraph number 4 of the IA, my lord. Paragraph number 4 of the IA. That the opposite party plaintiff filed an objection against the petition filed by the petitioner defendant under Order 9, Rule 13, read with Section 151 of the CPC in the above mentioned missed case. The petitioner defendant firmly denied the statement made in paragraph number 7 of the said objection and stated that the petitioner defendant had no knowledge about the institution of pre-mediation case number so and so, so they could not appear before the mediator on the respective date fixed by the mediator. It is utmost important to mention here in the defendant number 7 of the money suit was the manager of the proprietorship firm so and so, who misleaded the defendant number 2 to 7 by saying that he will pay all the dues of the defendant number 1 to the plaintiff. That means they are admitting, my lord, that they have the liability towards me and they have made part payment, and it is their dispute between the defendant number 2 and 7. The 7 has took money from them, and in the meantime he had not paid me. So this is not appreciable in the course of delay. For the purpose of condoning delay of 546 days, my lord, there has to be sufficient cause. And the paragraph number 5, 6, 7, 8 does not state any sufficient ground. And if in that case delay is condoned, my interest will be prejudiced. I am not a company, my lord. I am an individual person. I have supplied the blocks. GST bill was raised. I have paid the GST return. And now at the time of releasing the payment, they are saying that my husband is dead and I am no more. I am financial hardship. But GST return shows, my lord, they are active status. They are active from right from the issuance of legal notice to the institution of money execution case. Now, after waiting for 4 years, my lord, I am at the stage of recovery. Now they have made part payment of rupees 13 lakhs. 34 lakhs was decreed in my favor, my lord. Out of them, they had paid 13 lakhs. Now I have instituted the execution case only for 26 lakhs, my lord. Though the decree was for 34 lakhs, I have mentioned in my execution case that they have made payment of 13 lakhs, and that is required to be set off, and execution should be proceeded for 26 lakhs only. So where is the case, my lord, for condonation of delay? Moreover, my lord, explaining that for the purpose of obtaining certified copy and preparation of RFA, it took 546 days to them to obtain certified copies. And no, my lord, this is not a well sufficient. Moreover, I will also rely on 25/2025 Supreme Court SC 814 recent judgment, my lord. Paragraph number 31, 32, and 33. This decision was passed on 13/5/2025, very recent, my lord. In paragraph number 31, 32, and 33, paragraph number 31, it was observed that it is a well-settled law that while considering the plea for condonation of delay, the first and foremost duty of the court is to ascertain the bona fides of the explanation offered by the party seeking condonation rather than starting with merits of the main matter. Only when sufficient cause or reasons given for the delay by the litigant and the opposition of the other side is equally balanced or stand on equal footing, the court may consider the merits of the main matter of the purpose condoning delay. Further, this court has repeatedly emphasized in several cases that delay should not be condoned merely as an act of generosity. The pursuit of substantial justice must not come at the cost of causing prejudice to the opposing party. In the present case, the respondent defendants have failed to demonstrate reasonable grounds of delay in pursuing the matter, and this is a crucial requirement for condoning the delay remains unmet. So, my lord, there has to be sufficient good. Just explaining that I have obtained certified copy that was not legible, so I have to obtain another. That took, my lord, 546 days. Whether this is appreciable, my lord, this is not sustainable. So delay should not be condoned. I am not a company. I am individual person, my lord. My interest will prejudice, my lord, if delay is condoned. So I pray for rejection of the IA petition, my lord.
One thing is very important, my lord. Now the opposite party number 2, he was my manager of the firm, my lord. Proprietorship concern, my lord. He, along with the plaintiff, my lord, in collaboration with this, my lord, Safik Barik, he was a manager. And after the death of the proprietor, they have managed, my lord, everything. Regarding the premediation, this case was nothing. They have no knowledge about this premediation, my lord, case. This Safik Barik, he is the now opposite party number 2 in this appeal and as well as in the miss case, my lord. They have managed along with this Safik Barik, my lord, this manager, and they have, my lord, shown that we have the notice was duly served. In fact, we have not received. Otherwise, we definitely have appeared before the trial court and have filed the written statement, my lord. Now regarding, my lord, this delay, when there is, my lord, we have some liability, we have admitted, but this is not as much as it is 31 lakhs or so, my lord. That's why, my lord, the evidence, the documentary evidence, they are all photocopies, my lord. They are all printed. They are not, we have not received anything, my lord. There is no signature of receiving these blocks, my lord. These documents are also not genuine documents, my lord. We have obtained certified copy and therefore took some time.
Heard Mr. Goswami, learned counsel for the applicant, and Ms. Mishra for the respondent. Opposite party. Argument concluded, order is over.
Much obliged.
Obliged, my lord. One certificate, Supreme Court
Pardon?
judgment. AR 1987, Supreme Court 1553.
Furnish it to Mr. Court Master.
12, item 12.
My lord, the other side was not there.
Lordship, our name is not shown in the post list.
So today you are not ready to argue the matter.
No.
I shall. Okay, when you will be able to argue the matter?
Should be next week.
Next week.
Thursday.
In the month of August.
Only when our names may be shown, because my name, I mean, my learned junior's name is not there also, my lord.
In cause list.
Yes, madam.
Yes.
Okay. Heard Mr. Roy, learned senior counsel, assisted by Mr. Chakraborty, learned counsel for the appellant, and Mr.
S. Burua.
S.
Burua.
S. Burua for the respondent. As agreed by learned counsel for both the parties, recess is the matter. 12 of August. 12 of August. It is submitted at the bar that the name of the council, respective councils, have not been reflected in the call list. Recess shall do the needful in this regard.
Item 15.
Lordship, maybe it is not possible to start this case at this hour. Lordship.
Okay, suggested it.
4:25, Lordship. Regular second appeal, Lordship. First, today is Tuesday, no? Thursday, Lordship. Or next Tuesday.
First week of August.
August, Lordship. Diary to 9. Diary 8 no money.
As agreed by learned advocates of both the parties, recess shall is the matter on 7th of August. 7th of August.
15 and 16, Lordship. 16 also, I am respondent and he is appellant.
Okay.
16, my lord, maybe
15 and
another date, not the same date, my lord.
Same date.
Not same date, my lord.
Same date may not be possible, yes.
Lordship,
Another date.
5th of August, Lordship. Then.
August. Item number 70.
16.
16. Can it be on 5th of August, Lordship?
No, already a lot of matters fixed.
Lordship.
7 and
Obliged.
16.
Item 19.
I am for the appellant in the second appeal.
Hmm.
Perhaps my
I'm for
lord,
the
time will
respondent.
not permit today. Because
Suggested it in the month of August.
Can it be on 29th July, my lord? Both
29th.
party have no objection. 29th
Same
July.
thing will happen.
Lord,
Already a lot of matters fixed.
19th August.
19th August. After.
As agreed by learned advocates of both sides, recess shall is the matter on 19th of August.
obliged.
Item 20.
In this matter, date may be fixed because matter is pending for quite a
This
long time.
IA is for what purpose?
IA was disposed of actually original. It was disposed of as original appellant.
For substitution.
Original defendant died. Normal Kejriwal is legally was impleaded.
Okay, as agreed by learned advocates of both the parties, recess unless the matter.
On 21st August.
Published.